Good morning, and welcome to another edition of the Senate Committee on Commerce and Labor. This is for the 81st legislative session, and before we begin, be sure to mute your mic when you are not speaking to minimize background noise. Madam Secretary, please call the roll.
Senator Hardy,
Here.
Senator Lang,
Here.
Senator Neal,
Here.
Senator Pickard,
Here.
Senator Scheibel, Senator Settlemeyer, Chair Spearman.
Here, Secretary, and please mark those who are absent right now present once they arrive. Okay? I want to welcome our audience that's joining us remotely and anyone listening over the internet. Today we have hearings on Senate Bills 307 and 308, and we have a work session on Senate Bills 184, 217, 229, 280, 314, and 320. A few housekeeping items. The legislative building is currently closed so that we can reduce the amount of spread and infection rate of COVID-19. This is for your safety and for ours. So all of our meetings are being held virtually, meaning committee members, staff, and everyone else will participate either through Zoom, video conference, or by telephone. But you can still participate. You may register to participate through Nellis, where you have the opportunity to testify on a bill or provide public comment during the meeting. You can submit written testimony to the committee email address or fax number listed on the agenda. You can share your opinion via the legislature's opinion application on Nellis, or you may view committee meetings online through Nellis or on the legislature's YouTube channel. To register on Nellis, please click the participate button near the committee meeting date and time and fill in the required information such as your name, the date, the agenda, and the item that you're interested in, and your position on the bill. Once your registration has been submitted, you'll get a confirmation screen, and you'll also receive an email with the number and meeting ID to call in at the time, that your information comes up. Just to note that while meeting registration is required, it does not guarantee you will be able to speak. Very similar to previous sessions when we were doing this in person. Comment and public comment may be limited due to time constraints, and I will announce the time frame, that is, how many minutes each segment has before we begin. That's for against, and neutral. It will be helpful if one person in your organization wishes to comment to remember ditto is a good response when someone has already covered your points. This allows us to have more people to comment during that time frame. And when you're on the phone line, please pay attention to the bill that is being considered and follow the verbal prompts provided by BPS staff so that you know which keys to press to raise your hand or unmute yourself. Staff will call on you to speak by the last 3 digits of your phone number. Their detailed instructions for participating in committee meetings are also available on the help page, which is linked to the banner at the top of Nellis. If you need assistance with any of these processes, or if you would like to receive electronic notification of the committee's agenda and minutes, please contact our committee staff at the email listed on the agenda. Any exhibits for the committee must be submitted in electronic format no later than 8 a.m. the day before the meeting. In addition, any person proposing an amendment to the bill being heard by the committee must first talk to the sponsor and let them know your intentions. I will not entertain any amendments if the bill sponsor is not aware of the amendment. The proposed amendment must be submitted in writing 24 hours prior to the meeting. Please include bill number, statement of intent, and your contact information. And when you're testifying, please remember to unmute your microphone, speak clearly, and project your voice so that those listening to us over the internet can hear you. A reminder to all those who testify pursuant to Nevada Revised Statutes 218E.085, it is unlawful for a person to knowingly misrepresent facts when testifying before a legislative committee. Anyone who does so is guilty of a misdemeanor. The chair or any member of this committee may request documentation to support your testimony. To committee members, during these virtual meetings, when an agenda item calls for a vote, our committee will be using roll call to do so. So when the secretary calls your name, please answer with yes or no so that there is no confusion. And if you have a question, please make sure that you raise your hand through the Zoom application. And by now, I think everyone is real familiar with that. Additionally, we are approaching the first House committee passage deadline, April 9th, and I urge all of those who are presenting or who have presented a bill and who are waiting for an amendment to please make sure that you contact our committee staff to let them know where you are in the process. After April the 9th, if we've not voted your bill out of committee, then it will die. So today, let's begin with our work session. And let me ask this question before we do that. Are there any senators who need to leave early? Any senators who need to leave early? I don't see anyone. I was going to do that, do the work session first if we needed to leave early, but since everybody's going to be here for a while, let's begin the hearing on Senate Bill 307. We have Senator Dondero Loop, Alfredo Alonso, Leaf Reed, Lewis and Roca, and Jeremy Warren, and Revision Beer. So let us begin. You're ready.
Thank you. Thank you so much, Senator Spearman. I know that Alfredo Alonso was waiting to be admitted to the room, so I just make that announcement so broadcasting will admit him. Thank you very much. Thank you, Chair Spearman. For the record, I am Marilyn Dondero Loop, representing Senate District 8 in Clark County, and I am pleased to present Senate Bill 307 for your consideration, which builds upon our previous efforts concerning the sale and distribution of alcoholic beverages. Almost every session, the legislature has contemplated and enacted legislation involving the three-tier system, craft breweries and distilleries, and in the past decade, Nevada's brewery and distillery businesses have grown each year. According to the American Distilling Institute, craft distilling grew into almost a $1.8 billion business in billion-dollar business in 2019, directly employing thousands and indirectly supporting thousands more in related businesses. At retail, these sales were reportedly worth $3.2 billion. And under Nevada's three-tier system, it is our local distributors and our middle tier that gets these craft breweries and distillers products to market. Nevada's distributors also employ thousands of Nevadans and directly provide goods to Nevada retailers. Preserving the independence of this middle distribution tier is essential, ensuring that distributors have the freedom to sell and promote all types of beers, wines, and distilled spirits, and it allows the growing craft brewers and distilleries to have access to the essential distribution they need. Recognizing the growing craft brewery and distilling industry while respecting the three-tier system is at the heart of this bill. I introduced this bill for three simple reasons. One, to ensure the continued independence of the distributor tier, making certain that small brewers and distillers have access to market. Without distributor independence, small brewers and distillers could be shut out due to the constant influence of large suppliers with enormous market share. Two, the orderly and consistent regulation and enforcement of liquor laws that protect the consumer and businesses that are licensed in Nevada. And three, finally, to continue to encourage our vibrant craft beer industry to continue to grow and thrive. Alcoholic beverages are generally governed by the 21st Amendment of the Constitution. However, individual states control the sale of alcohol within the state, distribution of alcohol within the state, importation of alcohol into the state, and statutes regarding who can possess alcohol in the state. In turn, state laws often assign different roles and responsibilities to local jurisdictions regarding the above issues. According to Senate Bill 307, it contains several provisions addressing each of the above issues, making various changes to the regulation of brew pubs, craft distilleries, suppliers, and wholesalers. Chair Spearman, at this time, I would like to turn the presentation over to Alfredo Alonso, principal, and his partner, Leif Reed, both of Lewis Roca, who will further discuss the need for Senate Bill 307.
Thank you. And before we begin, for all those who will be asking questions, no need to go through me. Please go direct to the senator or the committee member who has asked the question, okay? Mr. Alonso, proceed when you're ready.
Madam Chair, Alfredo Alonso with the law firm of Lewis Roca, today on behalf of Southern Glazer Wine and Spirits and the Nevada Beer Wholesalers Association. And we're very thankful for Senator John Darrell Loop's assistance on this very important issue. We had no real intent on being before you on another liquor bill. I know that this seems to be something that this committee deals with quite a bit, and historically, it is usually somewhat contentious, but that is what you deal with in a very regulated industry. You're going to hear why are we back? And I would tell you that in an industry where it took an act of Congress to ban a product and then an act of Congress to bring it back, and it's been regulated very heavily across the country ever since. Every state has different issues, and I think Nevada has done an excellent job of basically dealing with an issue with very little dollars on the enforcement and regulatory side. I think our tax department does an incredible job considering how lean they are. But these are oftentimes issues that are national. They ultimately affect us eventually in some fashion. And we're talking about, again, a middle tier in which this isn't your traditional franchise. You know, in many cases, a franchise might assist with with your buildings, with your infrastructure. These are Nevadans that have been here for generations, and every inch of their property, every truck they drive, and every employee they pay is their own. And so again, the importance of the independence of this tier is paramount to our system working properly, and more importantly, for new brands to get to market, as the senator indicated. We're here today because of some behavior that has happened over the past few years, in particular just before session, that I think we felt we had very little choice but to ask for help, and the help from the senator and the help from this committee. What you have before you, I think, is a good bill. It is regulating some issues that have been very difficult, that have hurt our wholesalers significantly. And again, it's happening during a pandemic, which is even more important. I'd like to introduce my partner, Leif Reed, who would like to go through the bill. And I also point out, we're still willing to have conversations with those that have issues with the bill. I think that we have pared down, as you'll see with Mr. Reed's testimony, in an attempt to basically do as little as we can or as we need to, but still assist our clients in being able to operate properly as an independent wholesaler. You'll also meet Jeremy Warren, who is a local brewer. He came out and asked us to help with his ability to grow. And in the bill itself, I think Leif will go into a little detail on it wasn't quite right. And so I think he'll go into a change there as well that hopefully addresses Mr. Warren's concerns.
So this is Leif Reed. Good morning. My law firm is Lewis Roca. I'm Alfredo's partner, and I also represent Southern Glazers Wine and Spirits and the Nevada Beer Wholesalers Association. And I'll walk through the provisions of this bill. I would say very briefly at the inception, just to provide a little bit of historical context. In 2009, there was a large merger between Miller and Coors, creating a company known as Miller Coors, or now known as Molson Coors. And the legislature enacted a bill at that time in 2009 to create a number of the protections that are being amended here in sections in NRS 597-157 and also in 597-162. 4 years ago, this committee also sat and heard a similar bill. It was also in response to a mega merger of large brewery, the Anheuser-Busch ABI merging with Miller Coors. And at that time, the legislature also passed additional protections, additions to NRS 597-162 that encapsulated or codified the consent decree provisions that the U.S. Department of Justice was imposing on Anheuser-Busch to make sure that even after the result of this mega merger, that wholesaler independence would continue, that the craft and small brewers wouldn't be harmed, and that wholesalers would be able to continue to distribute those brands and allow them to grow nationally. And we codified in the state of Nevada those provisions to make sure that that happened. Nevada was on the cutting edge of doing that. At the time, we were the first state to codify those provisions. A number of other states have followed. And as Mr. Alonso mentioned, as a result of that legislative action that's taken place here in Nevada 4 years ago, and more recently in other states like South Carolina and Michigan, Anheuser-Busch has taken action that negatively impacts wholesalers in those states. And therefore, these amendments to existing law that I will describe to you now are proposed to ensure that the purposes of NRS 597-162 and other provisions are strengthened to ensure that wholesaler independence continues, to ensure that the small breweries and craft breweries are allowed to flourish despite the concentration of monopoly power that exists with the large breweries. So in section 1, I'll describe each of the 7 sections briefly that are in SB 307. Section 1, existing law prohibits a supplier from unreasonably withholding or delaying approval of any sale or change of control of a wholesaler. And section 1 of this bill adds a 30-day time requirement to existing law, which requires supplier approval of a proposed sale transaction if the supplier to be substituted meets reasonable standards. Section 2, existing law prohibits a supplier that has more than one wholesale distributor of its brands within the state of Nevada from discriminating between such wholesalers with respect to terms or provisions of their franchises. Section 2 of this bill provides that pricing and freight charges are explicitly among the terms of a franchise, that a supplier may not discriminate between such wholesalers. Section 3 of the bill prohibits a supplier from requiring a wholesaler to keep minimum inventory of the supplier's alcoholic beverages or other products that exceeds the number of days of credit extended to the wholesaler by the supplier. It also prohibits suppliers from requiring wholesalers to make payments under terms that are materially different from the payment terms that the supplier imposes for its own payments. And the last part of Section 3 prohibits suppliers from attempting to circumvent Nevada law by requiring wholesaler to waive the rights and remedies that are available to them as part of under Nevada law, as part of the terms and conditions of their franchise or distribution agreements with suppliers. Section 4 authorizes, and this is something that we intend to clarify. Section 4 of the bill authorizes brew pubs operating in the state of Nevada to produce and sell an additional 20,000 barrels above what is currently authorized under Nevada law for export outside of the state of Nevada. And then sections 5 through 7 contain what are essentially technical amendments. Section 5 requires local jurisdictions to ensure that applicants for licensees aren't operating within multiple tiers of the three-tier liquor distribution system in Nevada. Section 6 of the bill changes the term vendor of liquors to supplier for consistency in the statute, and also to help ensure that licensee or applicants for licenses similarly with Section 5 aren't participating within multiple tiers of the liquor distribution system within the state. And then finally, Section 7 revises an existing exemption that exists under Nevada law for consumers who import a gallon or less of alcoholic beverages per month for household or personal use, to be the person that actually imports the product into the state. Those are the provisions that are covered by this bill. And as Mr. Alonso said, we thank Senator Don Darrell Loop, and we thank the committee for its time and consideration of this provision.
Thank you, Mr. Reed.
Thank you, Senator Spearman. And I would just tell you that both the proponents and opposition I've encouraged conversations between both sides, and I have had multiple conversations with both sides. So with that, I encourage you to and urge your support of Senate Bill 307. Mr. Alonso, you didn't have any closing remarks. I think we will stand.
Sure. I'd be glad to jump in.
Please, go ahead.
Thank you, Senator. Just a couple of things to go over while we can. Senator Don Darrell Loop asked us to sit down and have a conversation. We did that. It was quite spirited, as you can imagine. And I think we've been working very hard on trying to clarify some of the issues within the bill. Mr. Reed and one of our other liquor attorneys has been, in fact, worked into the night last night in an attempt to at least clarify some of these provisions. And I just want to go through very quickly. In Section 1, that does not require an approval. It's very important. And that, just to give you context, that was the Bonanza sale. That was basically putting a wholesaler and their family who had to sell their business in a position where they could not get an approval, even though the statute clearly said you couldn't unreasonably withhold. They couldn't get approval. So the brewery sat on it, ultimately costing them a significant amount of the value of their business, which again, there is nowhere else in commerce where that could happen. And yet it happened here simply because you had a large brewer knowing they could push around a small distributor. So if you read that, there was some confusion over what that meant. And again, it may say approve, but then you look down at the within 30 days after receiving notice of the transaction, if the person to be substituted under the terms of the franchise meets the reasonable standards. So we're not saying you have to. All we're saying is at some point within that 30-day period, you have to make a decision. And that's a very, very important thing here. I think it's again, something that we would discuss with them further. If the time period isn't perfect, we can have that conversation, but it does not require approval. Mr. Reed has also worked on section 2. All this means is you can't discriminate on freight and price. Doesn't mean you have to give everyone the same price. And I think we've got some clarifying language that Mr. Reed has been working on that again, hopefully we can supply that to all of you here shortly. I probably have something in my hands by now if in handing it to you if I could, but unfortunately, again, we worked late into the night trying to fix this. And then in the end of this section, there was some confusion over what ultimately we were trying to do with 9 and 13. And again, 9 is very simple. If you're requiring inventory, you give the wholesaler credit for those days of inventory. We're not saying that you are required to give credit of any kind, just if you require a number of days of inventory. If it's 20 days of inventory that you're requiring the wholesaler to have, it's only fair that you provide them with 20 days of credit. Just as an aside, within the chapter, you already have a provision that requires wholesalers to give their customers credit. They give them credit up to 45 days before they go to COD. So here we are in a pandemic, and we are giving our customers as much credit as possible, even beyond the statute, because we want them to survive. We'd like them to stick around, all of them. Unfortunately, our suppliers in some cases don't think the same of us. And so we have one particular supplier that cut our credit just before session. Again, it's not fair, and all we're asking for is fairness here. And then 13 is it's very simple. If you extend credit terms of any kind to us or requirements with respect to our paying for the product, and you owe a wholesaler money, whether it's for not product, but some kind of overage on marketing, or it's something that the brewery or our distillery is purchasing for a bar or another retail licensee. Again, if they owe the wholesaler, they ought to be paying them back in the same manner in which they would like to get paid themselves. Very simple. And then just to quickly go into the issue with the brew pubs. Mr. Warren and some of his folks and other brewers indicated that they would like to ship out and export more. It's really important for them to get a little bit bigger without, basically affecting those caps. And so all this does is say you can do an additional 20,000 barrels outside of the state. Again, allows them to grow without really affecting the marketplace. So we were happy to assist there. And then just lastly, just so that there's some clarity here as well, years ago, this legislature put in place a statute that allowed someone to go to a distillery out of state and purchase. If you purchase something, you could bring it back in as much as a gallon a month. There's been confusion over what import means. And so we're making sure that is very clear, that we're changing import to entering the state, so that's very clear for us and for tax and for any other regulator in the state. And that's I think when we get you the amendment, hopefully today, as soon as possible, I think you'll see that most of this is clarified so that, again, there's nothing, we're not trying to do anything out of the ordinary here and asking for simple fairness.
Thank you much, Chair Spearman and committee. And with that, we'll stand for questions.
Thank you, Senator Dondero. Are there any questions from committee members? Do I see any hands? Vice Chair Neal, and then Senator Pickard, Twin Towers.
Thank you, Madam Chair, and thank you, Mr. Alonso, for the explanation. So I'm going to ask you this based on the fact that you have an amendment coming. So in the amendment, in section 2, sub 13, where I know you just gave that explanation, does the amendment, what kind of leeway does it give? Because when I was looking at the terms, when it was saying materially different terms, when making payments, it didn't seem to allow like a price justification or when someone acts in good faith. So what is your amendment doing to that subsection?
What we're trying to do is make it just perfectly clear that you simply can't sit on money that is owed. I'll give you a great example. A brewer or a supplier comes in and says, I've got these coolers. I'd like you to distribute these to these customers. You can't do it because it's illegal for a wholesaler to provide anything of value. So it's coming from the brewer, coming from the supplier, whoever that is, and we tell them, you're going to have to pay us back. We clearly cannot give this. It's an item of value, and their answer is, we'll be glad to pay you back for them. We understand the law. We'll do that. And 3 months goes by, 5 months goes by, and we believe that we're essentially breaking the law at that point because we haven't been reimbursed. And so I think what we're trying to do is make it perfectly clear. And again, I think Mr. Reed can go into that, that you just simply have to use the same terms that you would expect from us in terms of payments. So if it's COD, then you got to pay us right away. If you're allowing for on these things, again, what's important to note that they remove anything that's owed right out of our bank accounts. So a wholesaler, doesn't really have a whole lot of say in this. If they owe money for whether it's a marketing dollar or a product, that comes right out of their account. So it's almost immediate. But if that's a 7-day period, we're simply asking for the same with respect to buybacks. And perhaps Leaf can answer that further if you'd like.
So I just have a quick follow-up because I get the illustrations and I understand like how you laid it out. But I think the thing that gave me pause was some of the terms that you're mandating through statute. Those terms are typically negotiated between the parties. And I guess what I was wondering is, why are we making sure, like in section 1, sub 5, it said can't alter terms. And so basically you're establishing set terms in law that would be terms that two parties would then negotiate and discuss and try to give the timelines based on what they feel is fair and what they feel is reasonable. And I guess that's what I was really trying to grapple with and understand, like, why are we restricting just simply the ability to contract what those terms would be and the manner? You know what I'm saying? Like you're codifying it in statute where it's just kind of, it's permanent and that term will not be adjusted at all.
With your permission, Vice Chair Neal, this is Lee Freed. If I could respond to that question. And I would respond by providing some context. This is in the context of liquor distribution. As Mr. Alonso mentioned at the beginning of the presentation, it's an industry that is different. It's highly regulated. It's an industry that has been involved in 2 amendments to the U.S. Constitution, and the most recent of those amendments and the acts of Congress that followed in the 1930s were heavily focused on the concentration of market monopoly power by breweries. And so so there have been statutory protections to help address the inequality in market power and position that exists as between these mega breweries and their local distributors, because one of the things that flows from the Constitution and into Nevada law is that it is in the state's interest to ensure that there's a separation of tiers within the alcohol distribution system, so that the suppliers don't control all tiers. And so when the legislature enacted NRS 597-162 4 years ago, it was in response to yet another mega merger of breweries. And NRS 597-162 has protections, prohibitions on what a supplier can't do with respect to its dealings of with its wholesalers. Among those things was a new provision. This is what we codified, a provision that the Justice Department imposed on Anheuser-Busch, and that was that Anheuser-Busch couldn't request from wholesalers, and it has continued to do so even 4 years after we in Nevada passed this provision in NRS 597-162. They have continued to ask for financial information about the sales of other competing products. When a wholesaler in Nevada that sells Budweiser and other Anheuser-Busch products, they sell other brands too. But Anheuser-Busch doesn't like that. And so one of the ways that they try to exert control is to ask for the financial information about the sales of those other brands, something they can't do. And we're before you now asking for more protections because Anheuser-Busch decided that since wholesalers in Nevada aren't going to provide information about their sales of other brands, information that Anheuser-Busch isn't permitted under Nevada law or under the Justice Department consent decree to request, that they are going to cut wholesalers' credit. And so when a wholesaler, which is required to keep 15 or 20 days of product on hand, Anheuser-Busch has recently required wholesalers to pay for that product COD immediately. Wholesalers, when they import the alcohol into the state, the first thing they do is pay the excise tax for that importation. Mr. Alonso also mentioned that by statute, wholesalers are required to provide credit in 45 days credit to retailers. And so wholesalers in the tough economic climate that exists during the pandemic are being required to pay COD for the product they receive and pay excise tax when they receive it. And then they don't receive payment from the wholesaler, from the retailers when they sell it until 45 days later. So it's created a difficult situation. And I would just lastly point out, it's a situation that wouldn't exist for wholesalers in Nevada if they only sold Anheuser-Busch products, because if they weren't selling the small breweries products or products like Revision, we have a Revision representative here, Anheuser-Busch wouldn't be asking for the financial information from those sales, and they wouldn't have a basis they wouldn't have withdrawn credit. They wouldn't be on COD terms. And so that's why we are where we are, and why we're asking for the increased protections that we're asking for, because of the coercive effect that the large breweries have, where they give disincentives through things like revoking credit from their wholesalers as a disincentive to allowing smaller brands to have a market in the state of Nevada.
Okay.
I hope that's answered your question.
No, it did. I'm just wondering, you guys worked this out last night that they are no longer going to restrain trade. That's what happened. That seems like a big win. So if you did, awesome. And I'll leave it there.
Senator Pickard?
Thank you, Madam Chair, thank you both, Alfredo and Leaf, for your presentations. First, actually, I want to go to Senator Dondero Loop, and thank you as well for bringing the bill. I was intrigued by the statement that these are local people, and I recognize most of the wholesalers are locals, but it seems to me in my discussion with Mr. Alonso and then with Mr. Hillerby that we're also talking about some billion-dollar, if not multinational, national wholesalers that are doing business here. Can you give me a sense, a feel for how much market the local wholesalers currently have?
Madam Chair, to you through Mr. Pickard.
Just go direct.
Thank you. Senator Pickard, I think you'll find wholesalers that are as small as a mom and pop, literally carrying one brand, importing one brand and trying to make a go of it, to more organized shops as small as Valley Distributing in Fallon that has a handful of employees, to the blocks in the rurals, Maury and New West up north, and then obviously your larger distributorships, Southern Glazers in 45 states. So it runs the gamut. It certainly does. There's no doubt about that. And so you will have a myriad of sizes and types and brands, and some of those brands, frankly, don't practice these types of behaviors. And to Senator Neal's point, yeah, we're reluctantly before you because these folks feel like they don't have a choice. Again,
Sure.
in comparison, we're talking these massive companies, international companies, against a small Nevada wholesaler in many cases. And so, negotiating on a contract is not necessarily easy. And I would tell you that many times these folks don't have a choice.
Having been a contractor for many years on the construction side, I have some insight into how difficult contracts can be to negotiate, even when you're small. I guess the reason I ask is because it feels like, particularly with Southern Glazers, which is, as you mentioned, 45 states, they're not unsophisticated. They're not the mom and pops that you've described to me in the past that are jumping in the truck if one of their drivers doesn't show up for work for whatever reason. But I feel like I'm a parent. I have 7 kids in a blended family, and 4 of them were 6 months apart. And when they were young, I was often intervening in a spat that really, they could have and should have, in my view, worked out for themselves. And I feel like I'm in that spot now. We've got, these sophisticated market participants who are asking the legislature to step in and settle their spat. And I just, and my penchant towards deregulation generally makes me want to just scream and say, guys, you're businessmen, go figure this out. But I will hand you that we have interjected ourselves already. So as a state, we're kind of stuck. We need to address this. But I guess part of my concern is that we're starting to enter into contract terms, as Vice Chair Neal suggested, that really should be worked out in my view, amongst you. So I guess where I'm going with this is explain why we need to get into the weeds like the credit. You suggested that Anheuser-Busch, I think you said, or maybe you didn't name them, but that just plugged into my head. They cut credit for wholesalers who didn't give them financial data as to why their or what their sales were outside, and that ultimately they're forcing product. Yet we've capped product in statute. Can you explain, number one, why we cap these things in statute? Number two, why it's important for the legislature to get involved and require specific credit terms?
I think, Mr. Pickard, again, Alfredo Alonso for the record, I think what we're doing here is not requiring credit terms per se. I think we could have very easily said, well, let's just mimic the chapter and say, hey, if we have to give 45 days of credit to our customers, we should have the same luxury. And we didn't feel that was appropriate. So we simply just took one portion of that, and that is when a supplier requires a certain amount of inventory. And in some cases, suppliers push inventory out to wholesalers that they've not ordered. They don't want, they don't need. And so you can imagine a wholesaler at, say, earnings time, and I'm not saying that happens every time, but that it has happened. It has happened often, where inventory is pushed out. Now we've cut credit. So think of it in those terms. I mean, how would you possibly have a conversation about this with respect to any terms and conditions when those terms and conditions change unilaterally on a regular basis, which is why we're before you, because there is no say. So you look at a Mr. Moretto at Valley Distributing in Fallon. He gets his credit cut. He's a small guy. He still has to pay the excise tax to the state. And guess what? That supplier may not have even paid him back yet for something that happened 6 months ago. That's the purpose of this this section. We don't want to get into contracts. We certainly don't, but there's some basic fairness issues here. that we have absolutely no say over. And there's nothing that's ever going to change that when you control the marketplace amongst simply 2 or 3 large brewers.
And I get that, but I guess I'll disagree to some extent that when we're talking about, inserting language, talking about materially different terms, we are talking about the terms of the contract. But I understand your response, and I guess you raise a question that I want to ask of the suppliers, assuming they, and I would be surprised if they didn't chime in. I'm going to want to know from them why we should be allowing them to control the inventory of the wholesalers anyway. I would think in the normal course of business, the business gets to decide what they take on, what risks they take on, that sort of thing. But let me just ask a more general question then. Because I don't want to hog too much of the time, because I could. I've got probably 30 questions written down. And when we're talking about the relationships between the wholesalers and the suppliers, why are we not insisting first that we look at things like arbitration or at least mediation to settle these disputes before we start taking a lot of legislative time? Why is it that the appropriate approach to this problem is to lock something in for 2 years and then go at it again in the next session? I just see this as, frankly, a waste of legislative time when these are really market-induced questions and concerns that might change from 1 year to the next. Why don't we, instead of requiring the terms be inserted in statute, why aren't we inserting a requirement that the two submit to binding arbitration or something like that first?
Mr. Alonso, may I jump in there before you, Mr. Reed? Senator Pickard, Marilyn Dondero Loop, for the record, I would submit that what comes before us in this body is many times subjective to what you believe. And it is our belief that this was an important bill. And while you may not agree with that or agree with the bill, that doesn't mean that it's not important legislation.
So, Senator, don't get me wrong. I understand the importance from the practical side of this, right? I'm just asking, why aren't we looking at a different means? Because we do this in other industries and in other contexts all the time, and where we require some level of mediation with a third party rather than duking it out. And it's more of the broad context. Why take our time to do this when, and we asked this question in courts as well. Why are we taking the court's time when this might have been resolved through third-party mediation?
I'll let Mr. Reed answer that. I'm not an attorney, but thank you very much.
So, Madam Chair, through you to Senator Pickard, I would point out that this is more than a contract dispute between parties. The provision that we, through this bill, are asking the legislature to amend codified provisions in a consent decree that the Department of Justice Antitrust Division, after completing an extensive investigation into the harms to the market that would occur from the merger of Anheuser-Busch with Miller Coors, that there were provisions that needed to be followed in order to prevent market harm and to prevent a monopoly situation where only limited products could be sold in the market. And so in order to ensure that there aren't barriers to small breweries and other products, these provisions were imposed by the Justice Department and the legislature here in Nevada 4 years ago considered it prudent to make sure that those provisions continued to be followed by the suppliers. So I would just point out that process so that hopefully gives you some comfort about the need for the regulation, and also some comfort that this is different from parties trying to negotiate contract terms, having the legislature do them for it, but instead we are following guidance that came out of a very full and extensive investigation by the Antitrust Division of the Department of Justice. And that's why those provisions were enacted 4 years ago, and why the provisions in Section 3 of this bill are proposed now to ensure that those ends continue to be protected.
All right, thank you for that. Yeah, thank you. I hadn't made that connection. That makes a lot of sense. So thank you for that response. Madam Chair, I'll take the rest of my questions offline. They've been very good to respond to me in the past, both sides. I would like to ask that question of the opposition if we get them on the line. Thank you, Madam Chair.
Thank you. Thank you. Senator Settlemeyer.
Thank you, Madam Chair. I appreciate the bill and respect that there are some disparagingly different negotiation abilities between the parties. And so I appreciate that that's trying to level the playing field a little bit. But some of the questions I had within the bill, specifically Section 7, I think that would end the concept. I mean, don't we already have entities that are shipping into the state, you know, whether they be like the Wine of the Month Club, whiskey samplers, you know, things of that nature? Would these effectively put an end to those type of programs?
Mr. Settlemeyer, Alfredo Alonso for the record again. That those programs under the current statute wouldn't be allowed. You can go to a distillery and purchase. You can take it with you. You can eat. You know, again, the language that we're changing is simply updating the word import, which import never meant direct shipping. It simply meant that you could bring in. I remember when it was put in the statute, it was basically a couple of small distilleries in South Tahoe that wanted the ability to be able to sell to Nevadans and be able to carry it across the line. And so what this does is basically clarify something that the Department of Tax needed, because it's more clear now, because there were some that felt they could start direct shipping into the state.
Okay. So how are the ones like the Wine of the Month Club and other programs like that currently operating?
Mr. Settlemeyer, currently there's a statute that specifically calls out the Wine of the Month Club. You can get a direct shipment of wine, a case a month, delivered to your home. So that's already in the statute. We're just simply making clear that the intent of that provision was never to import in large numbers. It was simply to allow the personal use. And so again, in consultation with the tax department, it was thought again that you by including the words entering the state with is more reflective of the original bill, original law.
Okay, appreciate that. One last follow-up, if I could, Madam Chair. Section 2, am I reading this correctly? You're going to create it so that freight prices have to be uniform, no matter where the location is. So if you're shipping potentially from Reno to Vegas versus Reno to Douglas County, that the freight charges are going to be equal?
So this is Lee Freed. If I could respond to the senator's question, that's not It's not the intent. The purpose is to make sure that they are, that if there are distinctions, that they be reasoned and justified and not arbitrary or imposed without a basis or justification.
And that may need a little more clarity, because where I'm reading it saying, including without limitation with respect to pricing and freight charges, would mean that if you shipped, a bottle of wine or a bottle of whiskey or wine or whatever, again, from Reno to somewhere in Reno, local delivery versus potentially all the way to Vegas, that pricing and freight needs to be equal. And that just seems, well, we know what that'll do. That'll drive up liquor prices. So people's beer, wine, whatever will go up, and that perplexes me. So maybe we need a little more clarification on that under section 2.
Mr. Alonso mentioned that we were working on amendment, and the amendment does focus on that provision that you're asking about. And so we do intend to clarify that, and make sure that unintended consequence isn't the result.
I look forward to reading the amendment. Thank you.
Thank you. I don't see any additional hands. So let's go now to the phones, and we will take comments in support. We'll do 15 minutes, 3 minutes per individual. Ditto is a good response so that others can have an opportunity to comment as well. If you do not get a chance to get your comment in, please submit it via email or fax to our committee. Thank you. So broadcast, we're ready.
Thank you, Chair. Good morning. To testify in support of SB 307, please press *9 now to take your place in the queue. Again, to testify in support of SB 307, please press *9 now. Chair, you have no callers in support at this time.
So let's go to opposition.
To testify in opposition of SB 307, please press *9 now to take your place in the queue. Caller with the last 3 digits of 300, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Madam Chair and members of the committee. Michael Hillerby, Hillerby, with Kemper Kroll representing Anheuser-Busch. On behalf of our client, we must oppose SB 307. Current law already gives Nevada wholesalers the strongest franchise protections in the country. At issue in the proposed legislation are numerous changes further limiting suppliers' rights, expanding the state's involvement in the terms of business relationships between suppliers and wholesalers, and further tilting the balance in the wholesaler's favor. Due to the time limits on testifying, I'd like to highlight one major component of the bill that would cause additional stress on the state's alcohol supply chain. Section 3, subsection 9 in the proposed legislation adds to current law that a supplier shall not require a wholesaler to accept delivery of any alcoholic beverage or any other item if accepting the delivery would result in the inventory of the wholesaler exceeding the amount of credit extended to the wholesaler by the supplier. This language is an impermissible attempt to mandate a supplier extend credit to a wholesaler under state law, or else risk the wholesaler refusing to accept the supplier's products. In practice, this means a supplier must extend a line of credit to the wholesaler, regardless of whether the wholesaler has demonstrated they have the ability to pay back the credit extended. In fact, current Nevada state law, NRS 597-162, subsection 5, states that a supplier shall not require a wholesaler to report to the supplier any of the wholesaler's financial information associated with the purchase, sale, or distribution of any alcoholic beverage of any other supplier. Since suppliers are currently prohibited from requiring complete financial information, a Nevada wholesaler, and because wholesalers don't provide the complete information, we cannot fully evaluate their ability to pay back the line of credit, and thus we do not extend credit to wholesalers in Nevada. If a wholesaler in Nevada or any other state pursued a line of credit from a traditional financial institution like a bank or credit union, they would absolutely provide their full financial information in order to obtain the credit. This is to make sure they have the ability to pay that credit back. If the wholesaler doesn't submit complete information, the bank is almost certainly not going to provide that credit. Further, as drafted, the language could mean that if a supplier does not extend any credit to a wholesaler, then the wholesaler would not have to buy any beer from the supplier. Essentially, $0 worth of credit means $0 worth of inventory. If a wholesaler has no inventory, how are they going to service retail accounts working Nevadans count on as places to purchase these products? The short answer is they won't be able to. Suppliers will have no route to market since they provide exclusive territories to wholesalers. Retail accounts will see massive out of stocks, and consumers will not be able to find the products they wish to purchase. Would be happy to answer questions, particularly hearing some of the earlier testimony today and questions from members, should you allow that, Madam Chair. Thanks very much.
Thank you, Mr. Hillary. Senator Pickard.
Thank you, Madam Chair. I do really appreciate the opportunity. Mr. Hillary, I wonder if you could speak to, well, first, let me ask a question about what you just said. With respect to offering credit, I've sought in the past lines of credit when I was working a large project and needed to pay payroll and needed that line of credit to make sure I could. But I never had the bank ask me about my contracts with others. They were never looking at other banks. They were never looking at competitive information. And it sounds to me like the suppliers are asking for, well, how much of my competition are you supporting here? That's the level of detail that would never be expected. So I'd like you to explain how that makes sense, but then also tell me why the supplier should be controlling the wholesaler's inventory. It sounds like the supplier does add, they ship product that wasn't ordered, and it creates a risk to the supplier. They're either taking inventory they may not be able to sell, or at least sell quickly, or they may overstock their warehouse. They're forcing the wholesaler to take warehouse space that they didn't plan on. How is that appropriate? And can you explain how that works?
Thank you, Senator Pickard. Michael Hillerby for the record. First, for years before the passage of the 2017 law limiting information, financial information, our wholesalers gave AB financials for many years, and they always represented other brands. AB has asked for full financials, not brand-specific information. Again, we think that's a perfectly reasonable request. It's the same kind of thing a wholesaler might ask of a retailer before they gave them product, for which the wholesaler had already paid. So again, we don't think there was anything untoward there. AB disagrees with Mr. Reed's interpretation of the consent decree, or that really needs to be dealt with in state law. There is a process with the Department of Justice or the D.C. court that's overseeing the consent decree on the issue of financials. To your question about inventory, NRS 597-162 sub 8, in this case it is page 5 of the bill starting at line 10, there's already limitations on what suppliers can do in terms of inventory with the wholesalers. There are limits there, and there are provisions that things can be negotiated in the contract. My understanding is AB has different inventory systems that wholesalers can opt in or out of, and it's really important to remember the wholesalers completely control the destiny of the supplier's product in a state like Nevada that has such a tight three-tiered system. We view those wholesalers as incredibly important partners. They're the only way we can sell product in this state, the only way to get it to a resort casino, the only way to get it to a restaurant, the only way to get it to a local liquor or grocery store so our customers can buy it, the only way to get it to a bar. Them being healthy, them being adequately stocked with inventory is critical. AB, like other suppliers, tries to be very sophisticated, to understand market events, particularly in a place like Nevada with major special events. And we've certainly seen a lot of disruption with that, and we worked closely with our retail and wholesale partners during the pandemic to try to make sure that they could move inventory and find new ways to do that. So that relationship's incredibly important. Anheuser-Busch or any supplier doesn't go out of their way to penalize a wholesaler They're trying to look ahead, look at events, make sure that enough inventory is out there, make sure that they're having an opportunity to get new products out that the public may be asking for. And again, there are contractual provisions that the wholesalers and suppliers can negotiate. With Anheuser-Busch, again, my understanding is there are different inventory systems that they can opt in or out of. So again, we think that's already covered. State law already provides important limitations. Further limiting those just damages that relationship and makes it even more one-sided for the wholesalers in this case.
All right, I appreciate that. And what do you say about the suggestion that much of this is the result of antitrust consent decree and trying to make sure that we're complying with existing expectations set at either the federal level or the contractual level? It sounds to me like these major conglomerates now, these multi-billion-dollar multinationals, have significant negotiating power and may not be following the spirit, if not the letter, of the consent decree.
Thank you, Senator Pickard. Michael Hillerby again for the record. AB believes that Anheuser-Busch believes it is in fact complying with the consent decree, and there is a mechanism should any party, wholesaler or otherwise, feel they are aggrieved by that. We don't believe the provisions as brought forward by the wholesalers 4 years ago and again now accurately reflect the provisions of the consent decree, or that this is the place to do that. Again, if the consent decree is the operative question here, there are mechanisms in place for the wholesalers to pursue that. You are right, Anheuser-Busch and other suppliers are very large, as are some of the wholesalers. Mr. Reed and Mr. Alonso's client, according to Forbes magazine, had $20 billion in sales in 2019. Not a small or unsophisticated company. One of the other large wholesalers, Breakthrough, sold $5.5 billion in 2019, according to Forbes. Again, these are not unsophisticated wholesalers that are negotiating with the suppliers. And so the other provision of the bill expanding caps, and we've had a number of these bills and some pretty heated fights over the years when the wholesalers have opposed the ability of brewers and distillers to manufacture product here. That just shows there is a vibrant market. There is competition. There are lots of options for consumers out there.
All right, I appreciate that, and I'll ask some more questions offline. Thank you, Madam Chair, for your indulgence.
Thank you. Additional questions from committee members? Okay, so let's go back to opposition. And I believe we have about 12 minutes left. 3 minutes per individual.
Chair, I believe we were currently in support. Is that correct?
Oh, no, I thought we were in opposition.
Oh, you're right. We are in opposition. I'm so sorry, Chair.
Please don't do that to me.
I'm sorry. I'm sorry. Caller with the last 3 digits of 729. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Madam Chair, members of the committee, for the record, my name is Katie Jacoy, K-A-T-I-E-J-A-C-O-Y. I'm Western Council for Wine Institute, a public policy association representing over 1,000 California wineries and associate members. We are here this morning in opposition to Senate Bill 307 as written. We have submitted testimony to the committee and oppose the bill because it amends the Nevada Franchise Act to add even more state-mandated terms to the private contracts between wineries and wholesalers, to the detriment of wineries and the benefit of the wholesalers. The law effectively ties wineries to their existing wholesalers and makes it virtually impossible for new wholesalers to enter the market. The state-mandated stifling of competition results in higher prices and reduced service, harming consumers. Since the franchise law has been enacted, there has been significant consolidation of the wholesale tier. Now, national mega wholesalers have substantial control over the market due to lack of alternatives. There is no longer unequal bargaining power that needs rectifying by state-mandated franchise protection. We do not see a public policy purpose for adding even more restrictive terms that further entrench the giant wholesalers. Section 2 prohibits differentials in freight charges, putting into question reasonable business practices currently agreed to by the parties. Freight charges depend on numerous factors, including mileage, size of the shipment, whether the shipment is palletized or broken pallet, and the mode of transportation. The smaller the market and the smaller the order, the higher the proportional freight costs to deliver the same item. Freight charges should remain flexible, not mandated by the state. Section 3, subsection 13 prohibits material different payment terms for winery payments to wholesalers versus wholesaler payments to wineries. However, these are different commercial transactions. Almost all wholesaler payments are for shipments of wine, standard business transactions. In contrast, winery payments to wholesalers are typically for special promotions. The winery needs to verify reports submitted by wholesalers. Payment delays can occur due to inadequate information from a wholesaler. To legislate against wineries for unintentional payment delays is an unfair intrusion into business practices. Thank you, Madam Chair.
Caller with the last three digits of 216. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Thank you, Chair and committee members. My name is Brian Reeder. That's BRIANREEDER with Ferrari Public Affairs representing Molson Coors. And Chair, if you don't mind, I'll be very brief and just say that Molson Coors is opposed to SB 307.
Thank you, caller. Caller with the last three digits of 523. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Chair Spearman and members of the committee. My name is Tom Clark. I'm here on behalf of the Distilled Spirits Council of the United States, also known as DISCUS. We join with the other companies in our joint letter to oppose Senate Bill 307 for a couple of reasons. The changes to the way wholesalers do business in Nevada are done in a way that greatly reduces the opportunity for small businesses to enter the marketplace. That includes a lot of startup companies and those entrepreneurs, many minority-owned companies, that want to do business in our state. Second, the current law allows Nevadans to have their hard-to-find or favorite spirits shipped to them by out-of-state distillers, spirits they enjoy for personal use. That's been no more apparent than during this pandemic. Thank you, Madam Chair.
Thank you, caller. Chair, you have no more callers in opposition at this time.
Thank you. So we'll go to neutral.
To testify neutral on SB 307, please press star 9 now to take your place in the queue. Again, to testify neutral on SB 307, please press star 9 now to take your place in the queue. Chair, you have no callers neutral at this time.
Thank you. Committee members, additional questions? I don't see any. I've asked Mr. Keene to dissect what the bill does with respect to NRS, just to make sure that everyone is clear on, especially the intent on NRS, but also what the issue is here. So, Mr. Keene?
Thank you, Chair Spearman. For the record, Will Keene, Committee Counsel. The issues one of the issues that seemed to be most in question was the change to Section 2 with regard to the freight changes. And certainly we can clarify language so that everybody's on the same page with what it means. But as I read the language, it seemed to me that the conditions for freight charges needed to be the same, such that if you're shipping to Las Vegas from Reno versus shipping to Elko from Reno, the actual dollar amount of the charges might be different. In fact, the rates might be different. But with regard to discrimination, say you had two people receiving shipments in Elko, what the shipper could not do is say to one person in Elko, you get one rate, and say to another person in Elko, you get a different rate. So the actual dollar amount of the freight charges could be different. The actual rates could be different if there's a reasonable basis for the rates to be different. But certainly if that's not clear in the language, we can clarify it. And I have not seen any of the incoming amendments, so perhaps that's something that is being clarified. As far as the other provisions, it is, for example, in Section 3, it's certainly true that these are putting into statute restrictions on the ability of the various parties to contract, and there are limitations on the ability for those parties to contract around statute. But these are all policy decisions. There's no legal problem with any of the provisions in the bill. And certainly for those who are concerned that some of these restrictions seem more detailed than we might see with other products, it's because with regard to alcoholic beverages, there is a different standard under the U.S. Constitution with regard to how the transportation and sales of alcoholic beverages is handled. And I'm happy to answer other questions if there's a particular question. Thank you, Chair.
Thank you, Mr. Keene. No, I just wanted to make sure that there was a clear understanding because I think that was the issue that was banted back and forth, and with different responses from each side. I just want to make sure that especially committee members and anyone else listening had a clear understanding of that. So thank you. Senator Dondero Loop, do you have any closing remarks, you or Mr. Alonso?
Thank you, Madam Chair and committee members. I would like, we have Jeremy Warren on the line, and I would like Jeremy to just close with his statement, and I would appreciate that time.
Okay. Yes, ma'am. Please proceed.
Madam Chair, my name is Jeremy Warren. I'm the CEO of Revision Brewing Company in Sparks, Nevada. Just want to go on the record and say we're in support of this bill, SB 307. I feel that it's very important for our state and communities to allow our Nevada wholesalers to maintain their independence without being negatively impacted by larger breweries. We're also in support of the bill with Section 4E by allowing our company and other companies in the state to produce more beer. By being able to produce more beer and sending more beer outside the state, it's going to allow us to create more jobs. It's going to allow us to bring that money from out of state into our state. It's also going to allow RBC to be more competitive with larger and regional breweries. It's going to increase awareness of the Nevada craft beer industry. It's also going to allow us to compete with the out-of-state breweries. And it's also going to allow us to increase the tax revenue in the state of Nevada. That's all. Thank you.
Thank you.
And with that, Madam Chair, I thank you. We've taken a lot of time this morning for a most important subject that I believe that with that, we can be done with this particular hearing.
Okay. You're paying me back for yesterday, aren't you?
Perhaps.
Okay. Thank you. And we will close the hearing on the perennial bill regarding beer. So thank you all very much. Let's move now to SB 308. SB 308.
Let me switch gears here, Madam Chair. Okie doke. Thank you, Madam Chair. Once again, thank you, Chair Spearman and committee members. For the record, I am Marilyn Dondero Loop, and I'm presenting Senate Bill 308, a bill that seeks to establish a work sharing program, which is an alternative to layoffs for employers experiencing a reduction in available work. COVID-19 recession abruptly displaced millions of workers in the United States, threatened with the loss of stable housing and imminent risk of financial ruin. In Nevada, there have been more than 878,000 new claims for unemployment benefits between March 14th, 2020 and March 6th, 2021. Unemployment insurance is the most important fiscal response the state and the federal government has during a recession because it sends timely, targeted, and temporary financial assistance to those directly affected by the economic downturn. However, what these workers need most is to know that they will be able to return to their previous jobs as the pandemic recedes and business returns. Workers who believe they are likely to be called back to a steady job can relieve workers' anxiety, which can bolster morale and increase consumer spending. Work share programs benefit businesses, workers, and states. Businesses retain their trained workforce for easy recall to full-time work when economic conditions improve. Workers keep their jobs instead of being laid off and collect reduced unemployment benefits to partially replace their lost wages. States save money by paying only partial unemployment claims instead of paying full benefits to laid off workers. Under approved work share programs, employees qualify for a percentage of unemployment benefits equal to the percentage by which their hours have been reduced. For example, an employee whose hours are cut by 10% would qualify for 10% of the state's established weekly unemployment benefits amount. While that does not fully replace the lost wages, the amount supplements a worker's income until they are recalled to full-time work. Currently, 27 states have work share programs established in law. States such as Arizona, California, Colorado, Connecticut, Florida, Idaho, Massachusetts, Minnesota, Missouri, Oregon, Washington, and Wisconsin all have these types of programs, among other states. This bill is quite long, but if the chair would like, I can provide a committee an overview of the substantive sections. We also have on the line Ms. Parvin and others from our Department of Employment Training and Rehabilitation. So with that, Madam Chair, would you like me to go through the sections of the bill, or would you like to go right to our specialists or questions from the committee?
I think why don't we do a high-level overview, and then we'll go to questions. And Vice Chair, I see your hand. So let's just high-level overview.
Okay, perfect. I will do that. Section 11 requires the administrator of the Employment Security Division of the Department of Employment Training and Rehabilitation to establish a work-sharing program to authorize payments for work-sharing benefits to eligible employees whose weekly hours have been reduced by a work-sharing employer. Section 12 requires an employer who wishes to participate in the work-sharing program to submit a work-sharing plan to the administrator for approval that must include certain information. Some of this information includes identification information of each affected unit covered by the work-sharing plan and its employers, and an estimate of the number of employees who have been laid off, identification of usual weekly hours of work and the specific percentages by which such hours will be reduced during the weeks covered by the work-sharing plan, a certification that if an employer provides health and retirement benefits to employees in the affected unit, such benefits will continue under the same terms and conditions, the written approval of the bargaining agent designated in a collective bargaining agreement if employees affected unit are part of such a collective bargaining agreement, an agreement to provide the administrator certain reports concerning the work-sharing plan, any other provisions added to the work-sharing plan by the administrator that the Federal Secretary of Labor determines to be appropriate. Section 13 requires a work-sharing employer that provides health and retirement benefits to an employee under a defined plan to credit the hours that are reduced under the work-sharing plan for purposes of participation, vesting, and actual accrual of benefits as the usual hours have not been reduced. Section 14 requires the administrator to approve or disapprove a work-sharing plan submitted by an employer within 15 days of receipt and promptly give written notice of approval or disapproval. Section 15 requires the notice to include an agreed upon effective date and the expiration date. Section 14 also provides for certain circumstances when the administrator must not approve the plan. Section 15 additionally provides that the work-sharing employer may terminate the plan at any time by submitting a notice to the administrator, and authorizes the employer to submit a new application at any time after expiration or termination. Section 16 includes provisions where the administrator may revoke approval of the work-sharing plan at any time for good cause. Section 17 authorizes a work-sharing employer to request a modification of an approved plan. Section 18 provides that the person is eligible to receive work-sharing benefits with respect to any week only if the person is monetarily eligible for unemployment compensation and is employed as a member of an affected unit under an approved plan. Section 18 also provides that the person be deemed unemployed in any week during the duration of any work sharing plan if his or her compensation is reduced based on a reduction of usually weekly hours. And Section 19 prescribes the manner which the weekly benefit amount for work sharing benefits are calculated, which is proportional to the reduction in hours for the employee under the work sharing plan. Section 20 requires work sharing benefits to be treated in the same manner as regular unemployment compensation with respect to charges to the experience rating account of an employer and the determination of an amount of reimbursement in lieu of contributions due from the employer that affects to make reimbursement in lieu of contributions. And finally, Section 21 provides that a person who has exhausted benefits from their regular unemployment compensation and work sharing plan may be eligible for state extended benefits. And with that, Madam Chair, I would like to invite, I'm not sure exactly everybody that's on the line, but I do see Ms. Parvin, I do see Dr. Tobin, and others on the line from Dieter that will be able to help and assist answer questions.
Okay, so I see Vice Chair Neal, and then Senator Pickard, and then Senator Hardy.
Thank you, Madam Chair. So I guess, I don't know who I should, I guess, is it part to Ms. Parvin? On Section 13, I had a question on the accrual rate. What is it? How will it accrue? Because I'm not clear on that. And then I have a question on 16 and 19.
Section 13?
Yeah.
Chair Spearman, this is Elisa Caffaretta with Dieter, and we are looking up Section 13 and the accrual rate. I don't see Linda.
Let me find it. So, okay.
Oh, there's Linda. Yeah. Linda, are you prepared to answer that, or should we get?
Well, I think Linda Parvin. Oh, sorry.
Let me clarify. So in Section 13, this is the section where you guys are basically saying they have their, if the employer is providing health and retirement benefits, and then their hours that are reduced under the work sharing plan must be credited for purposes of participation, vesting, and accrual of benefits. And I guess what jumped into my mind was how is, because typically the accrual is based on a certain length of time, or it's very complicated. So I was wondering how that's going to work, because their hours they're different, and the contribution is going to be different under this work sharing. Does that help it?
Yes. This is Linda Parvin. I'm the administrator for the Employment Security Division. In my experience with other states, it's done on a pro rata basis, but that is put out in regulation. And that was something that we would have to do if this bill passes, is promulgate regulations that will spell out all the different steps that are in these different sections. And Jeff Frischman is a consultant for our unemployment insurance program. Perhaps he has even more information than that, but that's what I know.
Jeff Frischman, for the record, as I understand it, the accrual rate would be equal to those who are not participating in the program, meaning the same workers who would continue full-time, that it would be at the same rate that they are receiving it, that they would receive it for those whose hours have been reduced.
Okay.
Does that help? To clarify? I think if you look at number 2 on Section 13, it points out that it would be at the same rate as those not participating, or in other words, whose hours haven't been reduced.
Okay. And so my next question is on, I'm going to skip section 16. I'm just going to jump to section 19. So if you go to section 19, sub 3, lines pretty much starts at 25 through 28, where this is the deduction, the work sharing benefits, because there's a whole lot in section 19, like a lot. And so when it says the work sharing benefits paid to a person shall be deducted from the maximum entitled amount of the regular unemployment compensation established for that benefit year, like I'm trying to give me the real example of how this works, because you're in a work sharing because your hours have been reduced, right? And so if you're gonna give me the real example before I get any deeper into that one, because the thing that triggered me was the deduction.
Okay, Jeff Frischman for the record. To give a real life example would be you have a casino who wishes to lay off or needs to lay off, makes a business decision to lay off 2 dealers. Instead of laying off 2 dealers, what they may choose to do in their plan, they develop the plan, is to take 10 employees and reduce their hours by 20%, thereby equaling the 2 employees. Are you with me so far? With that, they would then be reducing the real employee, their weekly benefit amount that they may be entitled to is, say, $400 a week. So since they have been reduced by 20%, their benefit then would become $80 a week. And that's what they would be eligible to receive under this program. Does that help? If not, I could read you another example provided by the federal government. Here's the example. An employee normally works a 40-hour work week. The employee work week is reduced by 8 hours or 20%. If the employee had been laid off and totally unemployed and determined eligible for unemployment compensation, the individual would have received a weekly benefit amount of $270. The employee submits an STC plan, which is the short-term unemployment compensation plan, and the plan is approved. Under the STC plan, the employee would receive $54 of benefits, or 20% of the $270, in addition to the 32 hours of wages earned from the employer.
Got it. Okay, thank you for that. So I'm gonna just skip to section 20 because, and then if time allows, I'll get back into the other questions I had on 19 because I had questions in sub 5 and sub 7. But in section 20, the way that the work sharing program is defined and the employer benefit that is being defined there, you know, I wanted to know what are the tax implications, because it said that the work sharing benefits must be charged to the employer's experience rating account in the same manner as unemployment compensation is charged pursuant to the chapter, and employers liable for payments of way and reimbursement in lieu of, right? So a couple of things stuck out, right? Tax implications to the person who is in the work sharing program, and when they and then the tax implication to the actual employer in that defined scenario. So can you talk to me about that?
Jeff Frischman for the record. Yes, the experience rating, the charges or the benefits that are paid to the employee, those benefits, just like in regular UI, would be charged against the employer's experience rating. So that doesn't change. The only difference would be that instead of, say, having 2 full-time employees and the employer paying in the example I read, the $270, they would be paying for 5 employees, the $54. So it's kind of a wash for the employer. The charge to their benefit experience rating is going to remain relatively the same. As far as the implications, the tax implications to the employee, they would be responsible for federal income tax, and that's of course with the IRS, and they would be responsible for, in the example that I read, the $54, they would be responsible for any federal income tax due on that $54.
Okay. Okay. Thank you. Thank you, Madam Chair.
Thank you, Senator Pickard.
Thank you, Madam Chair. I had similar questions, but before I do that, I want to kind of understand the broader context. As I understand this, we're talking about large employer organizations that are able to put these plans together in advance, get them approved, and then they will essentially allow the state to ameliorate any reduction in force or cost to the employees or the organization. So as I see this bill doesn't fix the immediate problem, because I agree completely with the sponsor here that our first responsibility to employees should be paying the benefits, right? Making sure that these people aren't out on the street with no resources, particularly when they've paid for this insurance. And I don't see anything here. In fact, this is going to take regulatory work first. So I'm wondering, number one, how does this affect the current backlog? Will this slow down the work being done to try to catch up with the 200,000 some that haven't yet received benefits? And how long will it take to get the regulations done before we can start seeing these potentially implemented?
Jeff, first.
Elisa Cafaretta with Dieter. Before Jeff gets into the specifics, I would like to clarify some aspects of Senator Pickard's question. The current backlog, we are working as rapidly as we can to continue hiring staff and implement technology solutions. I would say that the characterization of 200,000 people who have not been paid is not accurate. We can get you the current backlog numbers, but they are significantly lower than that because we have been making very good progress in getting through the backlog. So I just wanted to let you know that we would certainly provide that update, which we would say has nothing to do with Senator Dondero Loop's proposal to provide some additional benefits in the future.
Well, and I appreciate that. Respectfully, those were your numbers when you presented SB 75, and those are the last I've seen. So anyway, Mr. Yeah, go ahead.
Jeffrey Frischman for the record. If I could also, in your question, you referred to large employer organizations. This is not a program that is designed for large employer organizations. It is any employer with 2 or more employees is eligible to participate in this program. So this would benefit both the very, very small employer up to the very large employer. So let me clarify that piece of it, that it's not designed just for large employers. And the rest of it, what's left on the rest of the question?
How long to get
the reg? Oh, how long to get the regulation? We would anticipate, since there are, as the senator referred to earlier, 27 other states who have these types of programs, we would anticipate being able to review their regulations, and to get the regulations up and going, we would think would take, we could do it within the time frame. There is a conceptual amendment to this bill, and we would anticipate being able to do that probably by towards the middle of next year to have everything up and going. As far as taking away from our work on the backlog, this program, we would anticipate there's a strong likelihood that we would be able to receive federal funding for implementation costs to start the program. So we would not, thereby not having to take people away from working the backlog in order to do this, but this would be new funding coming in the door in order to set this up in the event of a further recession, economic turndown, to have this program in place and to prepare for the next economic downturn. So we would not anticipate any effect on slowing down the work on the current backlog that exists.
All right, that's great news. I appreciate that. And having been an employer both of small operations and at the executive level in Fortune 500 companies, I would submit that your small mom and pop with just a few employees won't have the resources to spend the time on developing a plan that then has to go through an approval process. This really is going to be, for practical purposes, pretty much reserved to those organizations that have the resources to be able to be working on a plan while they're still trying to keep their operation in business. So I appreciate that anyone could conceivably jump into this. I suspect that the employers that are having to consider work sharing that are smaller than a large organization will be focusing on their efforts just to stay alive. And so from a practical, and this also comes from, when I first read the bill and realized, I don't really know much about the work sharing program from an unemployment standpoint, jump online, do a little bit of research, and all of the examples that I saw from the states that you're describing were all large organizations that had gone through the process of getting their approvals. And so that's actually the segue to the next question. Do you have any data from the other states to show how long that approval process typically takes once the regulations are in place?
Jeff Hirschman for the record. We did meet with, or the staff did meet with the state of Oregon, and I do not recall seeing any information on that particular question. We could certainly follow up and provide that to you, but we don't have that information at our fingertips right now.
All right, that's fine. If you can follow up, that would be interesting, because my work on Sunset Subcommittee over the past couple of sessions or interims has really demonstrated that the ease and speed at which these types of programs take, that's critically important. So I'd love to know. I guess my last question that I'll ask currently is, I noticed that you've added a $400,000 or so fiscal note, but that appears to be just the administrative side. What do you think the impact is going to be on the trust fund when this thing is fully implemented? I know we're going into debt currently to cover the trust fund because we've exhausted that because of the pandemic. So is this going to further dip into that trust fund significantly that would extend what currently the employers will have to pay back? What's the increase that we're going to see as a result of these to the total trust fund expenditures?
Jeff Frischman for the record. I personally would not expect there to be any negative impact on the UI Trust Fund. I had mentioned earlier that it's going to be essentially a wash when Senator Neal asked her question, because rather than having, again, one person collect $270 a week, you would be spread to 5 people collecting $54 a week, which of course would add up to the $270. So it's really very even, it'd be even. So I would not anticipate any drain on the trust fund.
All right. I guess I thought that the administrative fees were part of the draw. Maybe that's not the case. Maybe the administrative fee. Yeah, my thought was, it's going to cost more to administer the program across 5 individuals than it would for one. And so that would be an additional cost. So maybe it's not to the trust fund, maybe it's to your budget. But my expectation would be that costs overall will go up because we're going to be spreading this out over multiple accounts. Is that just a misassumption on my part?
Jeff Frischman for the record. I would say yes, that might be a misassumption. What we looked at it to explain those administrative costs to help you better understand that maybe is that those costs were primarily geared at, number one, to initiate the program, to implement the program, which again, I believe we will be able to, I strongly believe we'll be able to get federal funds in order to stand the program up. Those, that initial fiscal note was if we did not receive federal funds. That's would be what we anticipated the cost would be to do the computer programming and a little bit of labor costs involved in that.
All right. No, I appreciate that. And of course, I think you're wise to do it that way because we don't want to count the federal dollars until we actually receive them. But at the end of the day, we're still trying to get out from under whatever that backlog is, and that's got to be, the department hasn't asked for the money for modernization. I'm hopeful that some of that will come out of the what I've been referring to in this committee as Biden bucks. I hope that gets paid for because I'm assuming the programming you're talking about now is in the 30-year-old COBOL system, unless you're buying new equipment off the shelf like you did with the PUA system. But then we potentially have a third computer operation that doesn't talk to the other two, and I just see this disaster snowball increasing. We really need to get our arms around the immediate emergency before we take on, in my view, before we take on additional. But anyway, I'm off the bill. Thank you, Madam Chair. Appreciate the opportunity.
You asked 3 questions beyond the one you said was the last one, too.
I'm sure I did. Thank you.
We'll take it off the next time, okay? Senator Hardy.
Thank you, Madam Chair. I'm going to just ask naive questions, I guess. This has nothing to do with somebody who lost their job. It's what I would call a reduction in force of time spent in the job. And so it gets money to make up the salary of the salary reduction because they had a loss in time, they got paid less? And is this money that makes up for the loss in time being recompensed, get them back up to their full salary, or is it less than unemployment would give them?
Jeff Frischman, for the record, will provide replacement of part of the money from which they was reduced. It will not make up the entire amount, but it will be a partial benefit to replace that percentage of lost wages.
So will it be more than or less than if they got unemployment?
It would, Jeff Frischman, for the record, it would be less than if they got unemployment. This is unemployment they'd be getting, but it would be less than the maximum amount of benefits that they would be entitled to.
So what would be the motivation of somebody to work less but still have to work in order to get paid less? If they were on unemployment, pure unemployment, what's the motivation to keep working?
Jeff Frischman, for the record, I'm not sure that I was clear in my response to you. They would be earning, for instance, in the example I gave, the 32 hours of work that they would be earning at their regular pay, and then the 8 hours a week that they would have been reduced, they would be receiving a partial unemployment benefit to help offset that 8 hours of lost wages. Does that help clarify that for you, sir?
So they would be taking home more money under this program than they would be from if they were on unemployment alone.
If I might, this is Elisa Cafaretta with Dieter. Yes, the short answer is yes. So Senator Hardy, if I could, when you go on unemployment, you are not making your old wage. Say you were making $1,000 a week, you make about 500.
Would be about 500.
About 500, and that's actually higher than our maximum. So you'd be making 467. So you're not. It's a partial wage replacement. It's not a full wage replacement on unemployment. What this program offers, if the employer wants to, it's a real benefit to both the employer and the employee in many situations, because the employer keeps a well-trained employee. They don't have to find someone new when the economy rebounds. They can keep them up to speed on their skills. And the same benefit applies to the employee. They can keep their hand in, they keep their, in addition, they get their healthcare benefits and retirement benefits. And even though their hours have been reduced, some portion, they get about half of that is replaced under unemployment benefits. So it softens the blow a little bit, and it keeps sort of your business going. The employee keeps their job, and they don't have to find a new job. So for employers that can use this program, and there is, even though it's available to folks with more than 2 employees, it's realistically probably a little larger than that. There is a significant benefit. It's just more flexibility in sort of continuity of business and sustainability of your business.
I appreciate that. So could a state of Nevada participate in this, or any private business, whether they were collectively bargained or not, participate in this?
Jeff Frischman, for the record, any employer with 2 or more employees can participate in it, whether they are a contributory employer, meaning a private type of employer, or if they're a reimbursable employer, they pay contributions in lieu of the money that's been paid out, meaning this, for instance, your example of the state, it's available to any employer within the state, yes.
I appreciate it. Thank you. Thank you, Madam Chair.
Thank you. Senator Neal, I think you had an additional question.
Thanks, Madam Chair. So the question was on, I believe it's section 19, sub 7. I want to make sure. It was related to when a person, it's lines 21 through 25. Well, let me take two provisions together because I was reading sub 5A where they have the two jobs and you put in the 10% in play. But what I was trying to understand is how did you come up with that measurement? And when I was reading section 19 sub 5A about the measurement, and then I went to sub 7, there are a couple of questions there, but let's deal with the measurement piece of the 10%.
Jeff Frischman, for the record, what this is referring to is the program, and I trust, and I'm not sure, this would be really a question for Senator Dondero Loop, is the verbiage for this is, I trust, is taken out of, I'm not sure where that language came from. I'm assuming that it's part of the federal regulations that oversee this, or was taken out of it from another state. I believe that for the feds to provide the funding that they do, that they are going to have certain requirements, which I believe this 10% is where that came from. In other words, if your hours aren't reduced by, in a regular 40-hour work week, if they're not reduced by more than 4 hours, is it really worth participating in this? I think is where that measurement comes from, Senator. Does that help you?
Surely, I'm going to read the, I'm going to read that federal language, I guess. So I can get clear. I'm not going to put Senator Dondero Loop on the hook on that one. Thank you.
And for the record, Jeff, just for the record, I was not trying to put her on the hook either.
Yeah, I think I'd have to answer to my own chair. So
like phone a friend time.
So in section, the last question on sub 7, this is the where they're working for another employer, and it's like there are two employers involved, but one they didn't work for, and how this disqualifying income comes into play for their regular unemployment compensation. I just wanted you to, help me understand, I guess, how that provision works. Once again, a real life example of it.
Okay, Jeff Frischman, for the record, what you may have is a situation where I am working for ABC Plumbing, and in the evenings I might be working for at a convenience store. If ABC Plumbing reduces my hours, but yet I'm continuing to work those part-time hours, this is addressing that dual income that I would be bringing in, and how that income could or would affect my potential benefits.
That's similar to existing.
And that's no different really than what we have for existing. If I was working for ABC Plumbing and I got totally laid off, the earnings that I had from that second employer could and would potentially affect my weekly benefits that from the job that I was laid off from. Essentially, and I can't remember if it's $50 or $100, the first $50 or $100 you earn are fine, they go into your pocket. Any earnings above that reduce dollar for dollar against the weekly benefits of unemployment. That's the current, and that's how the program is working today.
Okay, thank you for that. Thank you, Madam Chair.
Thank you. I just have a couple of questions and compared to the ones that have already been asked. This is probably elementary or pedestrian, but let me try, stab at it. First of all, is this program mandatory? Do companies have to participate, or is it an option?
Jeff Frischman, for the record, this is an employer-driven program. An employer must opt into the program. It is based on their own business decisions and their business needs. So it is not a mandatory program. It is voluntary for the employer. An employee may not opt into it, but the employer is holding the cards, let's put it that way,
Okay.
of whether or not they choose to participate.
Okay, so if a small business said this is not going to be worth my time, they wouldn't have to do it. Is that yes or no?
Jeff Frischman, for the record, that's a yes.
The next one is this connected? And I guess it is connected. You all have already answered the thing about the salary. So is this connected to some of the programs that are being implemented at the federal level?
Jeff Frischman, for the record, the USDOL has earmarked $100 million for states to get grants. This was announced in March of last year. So it's not a federal program. It's a piece that can be added by the states to their state UI programs.
Yeah, so I guess simplify it, $100 million, if that's what was to be allocated inside a bill in March. Does the legislation have to pass before we get that money, that extra money? Does it have to pass Congress? It just, the House and the Senate, does it have to pass Congress before we get that money?
Jeff Frischman, for the record, no.
I think that was all that I had. So seeing no other questions, broadcast, let's go to support. 15 minutes, 3 minutes each. Someone has already said what you wanted to say. Ditto is a fabulous answer.
Thank you, Chair. To testify in support of SB 308, please press star 9 now to take your place in the queue. Again, to testify in support of SB 308, please press star 9 now. Chair, you have no callers in support at this time.
And we'll go to opposition.
To testify in opposition of SB 308, please press star 9 now to take your place in the queue. Again, to testify in opposition of SB 308, please press star 9 now. Chair, you have no callers in opposition at this time.
Let's move to neutral.
To testify neutral on SB 308, please press star 9 now to take your place in the queue. Again, to testify neutral on SB 308, please press star 9 now. Chair, you have no callers neutral at this time.
Thank you. Senator Dondero-Loop, you have any closing remarks?
Thank you, Madam Chair and committee members for hearing Senate Bill 308. This bill, as we have discussed, is not really a short-term fix. It's to better serve our Nevada citizens in the future. And I would like to especially thank Ms. Cafferata and her team for all you have done for all of the citizens during the pandemic. And I certainly appreciate your time and expertise in being here today. And committee members, I would love to have your support for Senate Bill 308. Thank you.
Thank you, ma'am. And to that point, I agree. It hurts my heart to know that so many people have suffered. Director Cafferata, can you answer this? And maybe not, but what is the average unemployment for an individual? Just give me an average. I mean, what are we talking about, weekly or monthly?
Elisa Cafferata, just to clarify, Senator Spearman, are you asking us for the benefit amount or how
Yes.
long folks are staying on?
Yeah, no. If someone were to get unemployment, regardless of how long they stay on, what is the average amount that they would get?
300 is about the average.
Off the top, Elisa Cafferata, for the record, off the top of my head, and we will get these numbers for you. The maximum you can get per week in regular unemployment, where your employer has contributed in, is 467 a week. We think the average is closer to 300 something a week. And then there also is the self-employed, it's not covered by this, but the self-employed gig workers, that's 480 something a week maximum. And I don't know that I've seen an average number, but we can get those numbers for you. It is, again, intended to be a partial wage replacement as a bridge to a new job. And it is, we've seen in the past in situations of long-term recessions, former employees need a lot more supports. And so you'll start to see us talk a lot more about our workforce training and supports for folks in addition to unemployment, which is only part of the solution.
Okay, thank you. I'm just trying to get a handle on, so the figures that you gave me range anywhere from $1,200 and some change to $1,600 and some change. So it would be fair to say that people who are on unemployment did not receive a total of $2,000 a month, yes or no?
Elisa Cafferata, for the record, I would add that in this particular pandemic, we had several bills from Congress that added to that weekly amount. So for a time, there was the $600 a week additional. So folks were receiving closer to 1,000 a week. So in those months, they were getting 4,000 a month. Currently, there is a congressional support of $300 a week. So if the average is 300 and you get 300 more a week, it's $2,400 a month on average right now. And thank you for making me do mental math.
That's okay. I just have one more because I heard you say for a time. So that means that was there a time when the federal government could not or was not contributing the 600 or 400 or whatever? Was there a time when that didn't happen?
Elisa Cafferata, for the record, yes. So we had the CARES Act, which provided $600 a week for a couple of months. We had lost wages, which provided an additional $300 for 5 weeks. In Nevada, and currently the Continued Assistance Act and the American Rescue Plan are for this year providing an additional 300 a week. So, and that we had no control over. Those were congressional allocations.
Yeah, that's okay. I was just trying to get a handle on when did it stop? And that's what I don't, the names are irrelevant right now. I'm just trying to figure out when did the additional payments stop?
Lisa Cafferetta, for the record, the $300 a week additional is in place now. And we can give you a timeline from last year of when those additional payments were on and then were off again.
Okay, yeah, and that's what I was asking. The pandemic has touched all of us, and anyway, yeah. So thank you. Thank you for answering that question. Committee members, any other questions? Okay, so we will close the hearing on Senate Bill 308. Thank you, Senator Don Darrell Loop and others for bringing this information to us. So now let's begin the work session on Senate Bill 184. Mr. Melgarejo, please begin.
Thank you, Madam Chair. For the record, Cesar Melgarejo, Committee Policy Analyst. And the first bill in our work session is Senate Bill 184, sponsored by Senator Hardy. The bill revises provisions relating to the practice of medicine. And Senator Hardy has submitted a conceptual amendment, which is attached to this work session document. And that proposed amendment is to delete sections 3, 5, 7, 9, or as you were, 3, 4, 5, 10, 17, 18, 22, 29, 34, 37, 38, 40, 41, and 45 of the bill, which make various changes regarding issuing a PA license, supervision of a physician assistant, and authorizing a physician assistant to use the title of inactive physician assistant. And those were all the amendments.
Thank you. Oh, wow. It's a wonder we have any bill left. Seemed like you read all of it. Committee members, any questions? Seeing none, I will entertain a motion.
Move, amend, and do pass.
Have a motion from Senator Pickard. Do I have a second?
Second.
I have a second from Vice Chair Neal. Additional discussion? Madam Secretary, please do a roll call vote.
Senator Hardy?
Yes.
Senator Lang?
Yes.
Senator Neal?
Yes.
Senator Pickard?
Yes.
Senator Scheibel?
Yes.
Senator Settlemyre?
Yes.
Chair Spearman?
Yes. Thank you. Records show that the motion passed unanimously. Senator Hardy, would you take the floor statement?
Thank you, Madam Chair. Be happy to.
Okay, thank you, sir. Let's go now to work session on Senate Bill 217.
Thank you, Madam Chair. For the record, Cesar Melgarejo, Committee Policy Analyst. Senate Bill 217 was sponsored by Senator Severs Ganser and revises provisions related to applied behavior analysis. Molly Halligan, Chair of Public Policy Committee of the Nevada Association for Behavior Analysis, proposed the following amendments, which are attached to this work session document. And the first amendment is to amend sections 46, 47, 49, 59, and 83 to delete the phrase equivalent credential in the newly proposed or existing language of the bill. Second amendment is to amend subsection 2B of section 53 to include that the additional proposed member of the Board of Applied Behavior Analysis may be a person licensed as a behavior analyst or an assistant behavior analyst in this state. Third amendment is to amend subsection 1G of section 67 to include that a licensee or registrant is subject to discipline if they violate a regulation of the board, including without limitation the requirements that the licensee or registrant comply with any applicable requirements concerning ethics prescribed by the Behavior Analyst Certification Board or its successor organization. And those were all the amendments.
Thank you. Committee members, any questions?
Chair Spearman?
Yes, Senator Scheibel.
Not a question. I just wanted to point out for our staff that I don't think the work session document is available on Nellis. It was emailed to us, so I'm able to look at it while we discuss this, but we might want to get it up there at some point. That's all.
Okay, thank you. Thank you. And they're probably working on it even as we speak.
Probably.
Okay, additional questions? I'll entertain a motion to amend and do pass.
Amend, do pass.
I have a motion from Senator Hardy. Do I
I'll
have
second it.
Second from Senator Pickard. Additional questions? Thank you. Madam Secretary, please conduct a roll call vote.
Senator Hardy?
Yes.
Senator Lang?
Yes.
Senator Neal?
Yes.
Senator Pickard?
Yes.
Senator Scheibel?
Yes.
Senator Settlemeyer?
Yes.
Chair Spearman?
Yes? And let the record show that the motion passed unanimously, and I will give that one to, pro statement to Senator Sievers-Gansert.
Thank you, Madam Chair and committee members.
Thank you. We'll go to work session on Senate Bill 229. Mr. Maglarejo.
Thank you, Madam Chair. For the record, Cesar Maglarejo, Committee Policy Analyst. And just to notify the members, we have updated or uploaded some recent documents to some of the bills later on in the work session. So if you're looking at this information on Nellis, you might want to refresh your page. Senate Bill 229, sponsored by Senator Ratty, and revises provisions relating to the practice of pharmacy, specifically collaborative practice of pharmacy. Senator Ratty has proposed an amendment that's attached to this work session document, and which is to delete subsection 2 of section 4, which requires that the State Board of Pharmacy approve the written guidelines and protocols developed by a registered pharmacist in collaboration with a practitioner, which authorizes a collaborative drug therapy management. In addition, we have received another amendment that's also attached to this work session document from the Honorable Joseph Heck on behalf of the Nevada Osteopathic Medical Association, which proposes to amend subsection 2 of section 2 to prohibit a practitioner who enters into a collaborative agreement from being so geographically distanced from the collaborative pharmacist that it creates an impediment to effective collaboration in the delivery and review of healthcare services. In addition, the amendment proposes certain requirements that apply in the use of a collaborative practice arrangement by a practitioner who provides healthcare services that include the diagnosis and initiation of treatment. And those were all the amendments.
Thank you. Committee, any questions?
Yes, Madam Chair. I had a question on the language in the it's section 2 of 2. It's underneath the geographical distancing about that provides healthcare services that include diagnosis and initiation of treatment. And then I was looking at the language, which was the green in section 2. So what I'm not clear on, are we prohibiting diagnosis, or are we saying they can do diagnosis?
Yeah, I think Senator Ratty is on.
Hello, Chair.
Yes, ma'am.
Sounds like my timing may be perfect. I apologize. We just wrapped up the Senate subcommittee, Senate HHS subcommittee. So I apologize. All I just heard was the last word, diagnosis. So if we could get the question again, I would greatly appreciate it.
Okay. So I was asking a question about the, in section 2 of 2, underneath, it has, I don't know if you want me to read it from the work session or the green, where we're talking about I'm trying to be clear if it's a prohibition to diagnose and do the initiation of treatment. This is under Dr. Heck, where it says, in addition, the amendment proposes certain requirements that apply in the use of collaborative practice arrangement by the practitioner who provides healthcare services that include the diagnosis and initiation of treatment.
So thank you for the question. So I'm very grateful to Congressman Heck, representing the osteopaths, David Wiest, representing the Board of Pharmacy, and Dr. Slamowitz, representing DHHS, who spent a lot of time working out the details on this amendment. And so I think that the appropriate person to start with would be Dr. Heck, whose amendment it is, but we also have Dr. Slamowitz here to add additionally as well.
Okay.
Thank you, Senator Reddy. Madam Chair, through you to Senator Neil Joe Heck, Red Rock Government Relations, on behalf of
just
Nevada.
go direct. Go direct.
Thank you. On behalf of the Nevada Osteopathic Medical Association, no, to answer the question, no, it does not prohibit diagnosis and the initiation of treatment. It just says that when in a CPA using diagnosis and the initiation of treatment, you must follow the subcategories 1, 2, and 3. Those are the criteria in order to be able to initiate diagnosis and treatment.
And we're talking about pharmacists within the collaborative practice.
Well, this refers specifically to the practitioner.
Okay. That's what I want a clarification on. Okay. Because I was reading it and I was like, so are pharmacists now diagnosing? Okay. Because if the answer is no, they're not, we're good.
Senator Neal, you are correct. The answer is they are not.
Okay, thank you.
Thank you for the opportunity to answer the question. Chair, did that get you what you need?
Yeah, Chair, I'm good. Thanks.
Madam Chair,
Yes.
I am concerned that that may not be interpreted. I don't know how the pharmacist is not diagnosing if the pharmacist is treating. So how can you separate those two processes? Is the practitioner the one that's always diagnosing and then the pharmacist is treating, or is the pharmacist not diagnosing, just treating without knowing what the diagnosis is?
Dr. Slamowitz, do you want to try to take that one?
Sure, absolutely. Senator Hardy, so based on the question, Section 2, as Dr. Heck referred to, is specific to the practitioner. And the other sections within the bill, Section 3 and 4, identify what needs to be included within the collaborative practice agreement and also within the protocol that exists within that agreement. Within the Section 3 and Section 4, it does define that the procedure for the practitioner to provide the diagnosis must be included within that protocol. So the pharmacist is not diagnosing, and they are only treating in terms of whatever has been approved within that protocol between the pharmacist and the practitioner.
Thank you, Madam Chair.
And I would just point out that there's another portion of the bill that explicitly says that a pharmacist can't, nothing in this bill allows a pharmacist to go outside of their scope of practice.
Thank you. Committee, additional questions? Seeing none, I'll entertain a motion to amend and do pass.
So moved.
Have a motion from Vice Chair Neal. Is there a second?
That was Senator Lang.
Okay, have a motion from Senator Lang. Do I have a second?
I'll do the second.
Okay, so I was right. Just okay, we have a second from Vice Chair Neal. Any additional questions, committee? Thank you. So, Madam Secretary, please do a roll call vote.
Senator Hardy,
There will be a no reserve right to change when we feel more comfortable with the reality.
Senator Lang,
Yes.
Senator Neal,
Yes.
Senator Pickard,
I'll be no for now until I better understand the amendment.
Senator Scheibel,
Yes.
Senator Settlemyre,
Yes, with now, but with some reservations.
Chair Spearman.
Yes, and the motion was passed. Senator Ratty, would you do the floor statement?
I'd be honored.
Okay, thank you, thank you. And so now we will go to Senate Bill 280. Mr. Melgarejo.
Thank you, Madam Chair. For the record, Cesar Melgarejo, Committee Policy Analyst. Senate Bill 280 revises provisions relating to the Real Estate Commission, and Senator Scheibel proposes the following amendments, which are attached to the work session document. The first amendment is to add a new section to the bill to amend Nevada Revised Statutes 645.060 to require that members appointed to the commission hold office for terms of 3 years. In addition, provided that a member serves until their successor has been appointed and qualified. The second amendment is to add a new provision to subsection 1 of section 2 to expand the qualifications of persons appointed to the commission to include representatives of minority or underrepresented groups to reflect the general population of this state. And those were all the amendments.
Thank you. Any questions? Senator Pickard.
Hey, Madam Chair, just a quick question on the amendment, specifically with respect to Section 2, the new sub C. The way I read this, it says, to the greatest extent possible, represent the minority or underrepresented group that reflects the general population. So the way I read this is that this would establish a quota based on that populations or subpopulations representation in the state. I'm wondering if that was the intent or if we're trying to increase to the greatest extent possible the number of minority or unrepresented groups that are on the board.
This is Senator Scheibel, and I also have Administrator Chandra here with me, who may or may not want to weigh in on this, but this does match language that is already in the NRS in 645.060, or sorry, not 060, elsewhere in the NRS. But to answer your question, it is more of the second than the first. Not trying to establish a quota system, but trying to avoid creating boards that are full of old white men, when we know that there are a lot of real estate agents and brokers and salespeople who are not old white men.
Senator Pickard, did that answer your question?
Yes, it just solidified my answer. Thank you.
Thank you. And so many times, unless we refer to that in statute, the comeback when there's no diversity is we couldn't find anyone. So, additional questions?
Madam Chair,
Yes, that's Senator Hardy.
I guess
Yeah, I don't see, because I don't see your hand, but I think that's your voice.
so how many old white men are on the board now?
Sharat Chandra, Administrator for the Real Estate Division. Senator Hardy, to your question, I think we had 2 women on the commission, but because of term limits, but right now it's all, I don't know about the age though, so.
Thank you.
Thank you. Senator Settlemyre.
Thank you, Madam Chair. I was just kind of curious, kind of following up on what Doc Hardy indicated. I mean, if we're worried about who puts these people on the board, isn't that up to the governor? So shouldn't we be able to trust him to appropriately put the right people onto this board?
This is Melanie Scheibel for the record, and I don't have an answer to that question. I think that the point of the amendment, which was proposed by the division, is to ensure that when we are appointing the board, we're not just looking at individuals, but we're looking at the makeup of the board as a whole. And the point is to encourage the governor, as he or she or they are appointing people to the board, are taking that into account. I can, having served in the legislature for almost 4 years now, I can relate to having had somebody send me an application or ask for a recommendation for somebody for a job, an award, a position. And it's one thing to look at every application individually. It's another thing to look back at all the applications that you've approved or all the appointments that you made and realize that you have appointed a board that doesn't reflect the community. And so to Senator Spearman's point, it's not to say that we're not going to hire or we're not going to select the most qualified person possible. We should always select the most qualified person possible. But if there is some other underlying reason, like perhaps structural racism, that is causing only members of the majority group or the privileged group to apply for these positions or to be selected, nominated, recommended for these positions, subsection C is supposed to tell the government or tell the governor to take a second look and say, wait a minute, I think we're missing some people here. Let's bring them into the fold. And to the extent possible, let's make sure that the Real Estate Commission includes women, people of color, people with disabilities, LGBTQ people, and isn't focused solely on groups of people who are already well represented in our government.
Madam Chair, this is Shrat Chandra for the record. Just wanted to add, I know Mr. Keene is on there, Will Keene, and I think some of this language he indicated came from other statutes where there's just a verbiage in there that, and really for us, it was just to facilitate a conversation because that was kind of the discussion that had at the last meeting, was adding language in there that would kind of just put a point in the statute to look for diversity. And so we just had this thought, and I think Mr. Keene can chime in here. He indicated that there were a couple of statutes throughout NRS where this language was used as a general qualifier, and it would be good practice to have it in our statute. And also, Senator Hardy, to your question, there's one woman commissioner, and she's from the rural appointment, and that's on the Real Estate Commission. So I was incorrect when I said all were male. There's one female representation right now.
Yeah, but if this is a good idea, then under 645090, we're going to stick in the clause that says, to the greatest extent possible, represent minority or underrepresented groups that reflects the general population of the state. So if we agree that that's the right thing to do under 645090, why aren't we also shoving it in under 645060, stating that the governor also has to the greatest extent possible? Why is it only on one section and not on both?
I'm not sure if this question is for me. This is Senator Scheibel for the record. I think it would be redundant on both of them, but if you're suggesting that amending it to add it to 645.060 would influence your position on the legislation, then I'd be open to a conversation about it.
I appreciate that. I just don't understand why come the governor doesn't already, we can't trust the governor to do the right thing. I just can't figure it out. And that's where I'm perplexed. And I don't know if I'll ever be able to get past that. We either trust the governor or we don't.
This is Melanie Scheibel again for the record. I would just like to point out that the statutes will outlast the governor who is currently in office. And so I don't think this is about putting trust in a particular person or even trust in a particular office. It is about establishing going forward a policy that we as the legislature believe to be the right policy and the objectives of the legislative body. And it will require to the greatest extent possible, that every future governor of Nevada, whether they share this vision or not, does what they can to promote it.
Yeah, Mr. King, can you weigh in on this, please? And I did have a question, and I don't know, Mr. King, if you can answer it or someone else. Can you please tell me if this wording, is this new wording from 2019, or did it exist prior to that?
Thank you, Chair Spearman. For the record, Will Keene, Committee Counsel. Yesterday, I had begun sketching out some of the language for the amendments as I was going over the work session document. And for the first question, with regard to the language, the green language that's being proposed to add to Section 2, Sub 1, Paragraph C, I had searched through NRS, and we have language that I think effectuates the intent of the requester. And that language that I had sketched out was that the members of the commission must be appointed so that as a body and to the extent practicable, the members of the commission represent the ethnic and cultural diversity of this state, including without limitation members of ethnic minority groups and members of other underrepresented groups. And by using language such as that, I think we capture the intent of the requester, but we are also mirroring existing language that has been around for a while in NRS. I don't have the history on all the provisions of NRS that do this, but just as two examples, in NRS 389.510 sub 2C, that requires the governor, in as far as practicable, which I think is important language, which we would have in here, that the governor shall appoint members of that council that's handled in that particular provision to reflect the ethnic and geographic diversity of the state. There's another provision in NRS 388.5966 sub 2 that requires various officials making appointments to the board there, that the members appointed have to reflect the gender, ethnic, and geographic diversity of the state. There's numerous examples that put different factors in there. But that's the idea, is that they're trying to get representatives who represent the diversity of the state, not hard and fast quotas, and it's only to the extent practicable. And as far as the history goes, these provisions have been around for various lengths of time. I could look at any particular one if you would like and trace out the history of when it was put in. Thank you, Chair.
I just wanted to see if this was protocol under Governor Sandoval or Governor Gibbons or anybody else. Is this? I just wanted to see if this is something brand new.
Thank you, Chair Spearman. For the record, Will Keene, Committee Counsel. They're not brand new. They're in existing statutes. I would have to look at one and trace it back to see when it was put in place. I could do that for you and get back to you.
No, because I was just trying to make sure this wasn't brand new. Because I think Senator Settlemeyer's concern was we either trust the governor or we don't. And if this is brand new, then that should be something that we probably want to take a look at. If it's not brand new, then that means that there have probably been some other bills that have been passed similar to this that would state the same thing, but not say we don't trust the governor. I was just trying to be clear on that. Thank you. Additional questions?
It looks like Senator Lang has her hand up.
Oh, okay. I don't see it on here, but okay. Senator Lang.
Thank you. With all due respect, I don't think this is about whether we trust the governor or don't trust the governor. What we just saw in an appointment for a committee that had 2 women on it, 2 males were appointed in those positions. That is a very clear example to me of why we need this language. And so I think whenever we have a committee that is appointed, we're telling the governor, these are the things that are important to us. Please take these into consideration when you're appointing a committee. I think it's really important to always remind people in this instance or any instance when they're appointing committees to make sure they're diverse and they reflect what Nevada is. And so I really like this language, and I hope that we pass this bill.
Thank you, Senator Pickard.
Hey, Madam Chair, I guess, I agree to the extent that we want to encourage diversity in everything, because diversity of thought, diversity of perspective, diversity generally enhances debate. The more varied our perspectives and experiences, the better the result generally turns out to be. I think it's a mistake, both practically and legally, to express our animus towards any particular group, old white men like me or otherwise. But I do like the idea of diversity. I just personally can't get past the point that we're inserting people that have nothing to do with facilitating transactions. I think it's a mistake, but I support the idea of diversity, always have, always will, and appreciate the intent here.
So you said that the people that are appointed have nothing to do with, I'm just trying to understand the question or the statement.
No, I was just saying that I do support the idea of diversity, because I think diversity is important when we're debating anything. Perspectives are different, and I don't think any one perspective is more important than another. And so I think it's a mistake to express animus in any legislative history toward any particular group. But I do think that diversity is a wise thing to try to achieve. I just don't like the way we're trying to go about it. And I guess I'm just suggesting we should probably seek diversity for the benefits, not out of an expression of animus towards any other group. Thank you.
Thank you.
Madam Chair,
Marty?
I'm looking at the proposed amendment, and one of the things that we've got in there is qualified. So obviously, we want somebody on the real estate board that is qualified, or the real estate commission that's qualified. And again, right now it's skewed towards one particular group, and recognizing that this will allow 2 more people to be appointed. At least I think that's what it talks about. And we have sent a message that we're interested in people who are qualified to be appointed. And in as much as we've represented people like me, old and white, maybe it's time to get qualified people who aren't as old and aren't as white. And I think the intent is there to put somebody in who...
Senator Hardy, can you speak a little louder into your mic, please?
Yep, I think it's time that we look at how we can appoint people. Originally, I wasn't real thrilled with this, but I think reality is we're going to give a message to those who appoint, what kinds of people we want to make sure are qualified and diverse enough to represent people who need to be represented. Thank you, Madam Chair.
Thank you. And I'll just say, just for the record, I think that this is the right thing to do. I was privileged to have an opportunity to speak for the for Truro, for the docs, or soon to be docs. And when Congresswoman Berkeley called me, she said they had requested that I speak on diversity and why that's important. I also had an opportunity to speak, at Nevada State College. And when I got the request, they said they wanted me to talk about diversity. I had a request, from Malcolm X's daughter, who teaches teaches at a college in New York, who asked me to speak to her class, and they wanted to know about diversity. So I think that we're on the right path, and in 2021, you would think that we wouldn't have to do this, but we do, because if you look around and you see, and to the point of the most qualified person, I'll say this as a Black woman, sometimes I've been the most qualified, head and shoulders above whoever was selected, but because I was Black, and one time I was told that. One time I was told that, well, I don't think that a woman or a Black woman can do this. Okay, so these things exist, and I think the point of, and I don't want to put words in your mouth, Senator Scheible, but I think the point of this is a way for us to walk our talk. Again, Senate Concurrent Resolution 1 during the 32nd special session passed unanimously out of both houses. That was bipartisan and bicameral. So I think recognizing that all the time the most qualified person is not picked for whatever the reason, and many times it's because of implicit bias. So having said that, I'll entertain a motion to amend and do pass.
So moved.
Have a motion. Is that Senator Scheibel or Senator Lang?
Senator Lang.
Okay. I got to put this back in gallery because I can't see y'all. I have a motion from Senator Lang. Do I have a second?
Second, Senator Scheibel.
I have a second from Senator Scheibel. Additional discussion?
Madam Chair,
Yes?
one of the things that we have to recognize is the Real Estate Commission does things with a lot of transactions and have to have qualification in the facilitating of those transactions. So the qualifications obviously are important for that particular board, not quote unquote just diversity, but for facilitating those transactions, knowing what they're doing. And to your point, there are people who are representing diverse communities that have capability to do that kind of thing. And I would hope we would empower the governor to look for those people who are qualified, and not just because of the color of their skin, but who are qualified, who actually show diversity in what we want to do and give hope for communities that want to be involved and have trust in the process that we have. Thank you, Madam Chair.
Okay, so with that, let me ask a question. Senator Hardy has indicated that the Real Estate Commission does various and sundry transactions. Is there anyone still on the call that could answer that question? What kind of transactions would they do? That the people, and I'm not saying that the person, whoever's appointed, shouldn't be qualified. Can anyone explain to me what kind of transactions they do?
Madam Chair, Sharat Chandra, Administrator for the Real Estate Division. I think to answer the question and your question, the Real Estate Commission is, a lot of the disciplinary action that the commission takes is related to real estate transactions. So these are licensees that go before the commission for things that they have done, either harm the public or created a conflict between the statute and regulations and what they were supposed to do. And so a lot of these come down to those details. Did you provide these documents? What was the transaction? How did it occur? Who were the parties? Were all the due diligence done? And so it becomes more of a, did you do all the things that you were supposed to do to protect your client? And if you didn't, then there is consequences to that, and related to the statutes and the regulations. And so those are the kind of disciplinary cases that go before the commission. The commission does also advise the division and also provide regulatory guidance and does regulations, but for the most part, the discipline is against licensees. It's not against just clients. It's about licensee discipline. So yes, they do get technical, and some of the transactionary details require some knowledge of real estate and understanding. So that's just to answer that question. Thank you.
Yeah, and I guess I probably should have phrased it a little. So the people who are appointed, are they realtors or not? Or have some affiliation with that, have some experience in that area?
Currently, Sharat Chandra, Administrator for the Real Estate Division. Currently, as the regulations and the statute reads, yes, every single member of that 5-member commission, which is currently 5 members, it has qualifications related directly to real estate. They're all practitioners. So that's, and this bill adds 2 additional positions. So I think there's 2 things here. The bill adds 2 additional positions and puts some qualifications around those 2 positions. So it increases the number of people on the board. The diversity question, I think, is a separate question. That is just a statement, to the extent possible, we need to do that. But the policy question, we have stayed away. We're neutral on the policy question, whether adding 2 more members to the commission and what their qualifications look like is something this body has been debating.
So, statement in question.
Madam Chair.
I know, hold on just a minute. I know some people who are realtors that are Indian, not indigenous Indian. I know realtors who are African American. I know realtors who are from the Latinx community. So if the pool of realtors, and I don't know if you know that because it's usually not on the license, but if the pool of realtors represents the population in the state, would it stand to reason that someone who would be qualified to do the transactions that you mentioned previously would have the experience to do that? That's my question.
Sharat Chandra, Administrator for the division, absolutely. There is plenty of diversity out there that can be represented on the commission, if that's your question.
Yeah, and I needed to ask that because I grew up at a time when we were trying to do diversity, and if you were Black and in a position and you were the first one, a lot of times people used to say, well, it's because of quotas. So I just need to be clear about this. And I think I just got a message that this goes back to, the wording goes back to 1999. I didn't live in the state then. Who was the governor? Does anybody know who was the governor?
May have been Miller, not sure.
Okay, Miller. Who was the governor after that? Anybody know?
Kenny Gwynn.
Huh? Kenny Gwynn? Okay, so the one thing we know is that this language has been applicable to Republican and Democratic governors. And so it's not a matter of do we trust, it's really a matter of protocol. And because we have to do this, my hope is in 20 years, people will automatically look for the most qualified person. And if a person of color shows up, then they will select them. But that's not the case right now. Senator Hardy, you had a question.
Thank you, Madam Chair. I really don't need to say anything more. Thank you.
Can you restate that? I couldn't hear you. Get closer to your mic, please, sir.
The good news is I said I don't need to say anything more.
Oh, okay. All righty. Senator Pickard.
Thank you, Madam Chair. I'd like to get away from the diversity piece. I think that's been beaten well enough. It's now glue. I want to get to the substance, and that is we're suggesting that we're inserting 2 non-expert or potentially non-experts, but who are consumer advocates for affordable housing. The difficulty I see in that is affordable housing advocates, or rather the realtors, the licensees have nothing to do with affordable housing. They don't set the rates, they don't set the prices, they don't set the availability. They really have nothing to do with the practice of real estate. And as a licensee, myself, we are required to understand how to facilitate transactions. That is the role of a real estate agent and or broker. to facilitate either leasing, property maintenance, and monitoring the management of it also falls under that. But at no time does a realtor have the ability to affect whether or not a price is affordable, whether that's on the leasing side or on the purchasing side. So by inserting people with a focus completely outside the realm of real estate, I believe that it's a mistake to add. Now, I'm not suggesting a non-real estate agent participate on the board, because that outside perspective might be interesting when it comes to disciplinary action. But to specifically require a focus on something that is completely outside the jurisdiction and purview of a realtor, or I'm sorry, that's a term of art, that's a trademark term, outside of a licensee, I just think it's a mistake.
Senator Scheibel, can you speak to why you inserted that, please?
Absolutely, Chair Spearman. With all due respect, I think that is exactly the problem, is that we have been looking at real estate transactions and the real estate industry as a separate industry from affordable housing. And I think it's time for us to bridge that gap. And for every individual who works in the real estate market, who helps people buy, sell, lease homes, rent out properties, invest in properties, has somebody in their oversight committee who is concerned about affordable housing and ensuring that all of our Nevada communities have adequate, accessible, affordable housing. And that's why I have suggested adding this person to the board, and I would request that we take a vote on the motion. Chair Spearman.
All right, so the question has been called. Madam Secretary, please call the roll.
Senator Hardy,
Yes, with the right.
Senator Lang,
Yes.
Senator Neal,
Yes.
Senator Pickard,
No.
Senator Scheibel,
Yes.
Senator Settlemyre,
Yes, with reservations.
Chair Spearman.
Yes, let the record show that the motion does pass. Senator Scheibel, will you take the floor statement?
Gladly, thank you.
Okay, thank you.
Senator Spearman, you're muted.
I said we have another bill, I'm sure. I'm just trying to find, I think it's, yeah. So let's begin a work session on Senate Bill 314.
Thank you, Madam Chair. For the record, Cesar Melgarejo, Committee Policy Analyst. Senate Bill 314 provides for the regulation of high-volume marketplace sellers on online marketplaces, and is sponsored by Senator Neal and heard on March 30th, 2021. I would note for this bill, there is an additional amendment that it was uploaded to Nellis this morning. So again, this is in addition to those amendments included in the work session document. The first amendment in the work session document is to delete Section 27 of the bill, which authorizes a person who is a victim of a deceptive trade practice to a private right of action. Second amendment is to add a new section to the bill to provide that the provisions of Section 2 through 16 of this act inclusive do not establish a private right of action against a marketplace seller, a high volume marketplace seller, or an online marketplace. Third amendment is to amend subsection 1 of Section 10 to change from 24 hours to 3 business days the amount of time when a high volume marketplace seller is required to provide certain identifiable information to an online marketplace after becoming a high volume marketplace seller. In addition, include that the information required in subparagraph A through E of subsection 1 to the online marketplace will be confidential between the seller and the marketplace and will be kept online, by the online marketplace solely for the purpose of maintaining records on the seller. fourth amendment is to amend a subsection 1 of section 11 to change from 24 hours to 3 business days the amount of time when a high volume marketplace seller is required to provide certain identifiable information to online marketplaces after becoming a high volume marketplace seller. The additional amendment that's included on Nellis would amend to increase from $5,000 to $7,500 the threshold for the definition of a high volume marketplace seller. In addition to these amendments and the one included on Nellis, Senator Neal also proposes to include an amendment to make the bill effective on July 1, 2021. And those were all the amendments.
Thank you. Senator Settlemeyer.
Thank you, Madam Chair. I appreciate the amendments. It looks like the sponsor's done a great job trying to deal with the outside, forces that are out there that are trying to get amendments to the bill and trying to make sure we have as little as possible of the unintended consequences. Unfortunately, in front of the documents I have in front of me, I don't have the effective date's pretty simple. I don't really care about that, but I was wondering if we'd have some discussion about the reasoning of trying to change the number from 5,000 to 7,500. Is there some data that shows that that's a significant chunk of individuals, or we just have some discussion about what's the reasoning behind that?
No. So thank you for the question, Senator Settlemeyer. No, there isn't. So what was happening was the folks that were in opposition to the threshold, they tried to get it. They wanted 20,000. I was trying to work with them. They wanted, I offered 10,000, and then they were like, no. And then I went to 7,500 just on my own because they kept saying that we were going to bring in hobbyists. And so I just selected that number, talking with retail to just go ahead and say, I'll at least increase the threshold since they were saying we were capturing hobbyists. I didn't have time to pull any data, but I didn't agree with raising the threshold to $20,000, which is what they wanted, because I felt like you're definitely probably getting into a high volume seller. And the issue that we're trying to go after, which is the organized retail theft, we could fall into that with a $20,000 threshold. And so I did 7,500, trying to consider maybe a hobbyist that might be doing 75 and under not being attributed to the threshold. So if that changes your opinion, I will drop it back to 5, but that's the only reason why I changed it.
One other question, just out of curiosity, is I think your bill goes a long way trying to address this problem. And I think one of the beneficial aspects is some of the other states have looked at similar legislations. Just out of curiosity, what level have other states used? Do we look at the idea of saying that, we should follow the amounts of other states so that way it creates some consistency? I was just curious if you happen to know that information.
So I'll let Brian Wachter answer that, but if we're going with consistency, then it would be 5,000. But I will let Mr. Wachter, you're on.
I am, Senator. Thank you, Madam Vice Chair. For the record, Brian Wachter with the Retail Association of Nevada. We would agree with the Senator that for consistency's sake, $5,000 would be the standard. Arkansas has just passed their language at 5,000. And I believe 5,000 was also included in the federal bill. We are very sympathetic to the hobbyist argument and certainly to Senator Neal. We feel that there really should be no amount of anonymous selling that could be done, and that the disclosure is really kind of limited so that it includes the hobbyist. But we appreciate Senator Neal doing what she's done, and $7,500 was the direction she went. But to be consistent, we would remain at 5,000.
Thank you for that explanation. And Senator Neal, it's your bill. I can support it in either fashion. I think there is something to say about consistency and, in that respect, but I can support it either way, whatever the pleasure is of the body or the committee.
Thank you, Senator Settlemeyer. I appreciate that, because it was a struggle, and because some of the provisions that they wanted to amend in like a sections 11, it was super hard to, accept those, because when I looked at the 1099, what is being asked for a sole proprietor literally is what we have in our bill. And so I just couldn't, I was like, if the IRS is getting it from you as a sole proprietor, you probably should be doing it in state law.
Senator Pickard.
Thank you, Madam Chair. Just a quick question, Senator Neal. I undoubtedly got the same mass emails that you did from the Etsy providers and others. And one of the things that I saw as an advantage in this bill from the outset was the, know your vendor kind of arrangement where having done civil litigation generally at the first part of my practice, that was always an obstacle. By eliminating the requirement that the information be publicly available, have we affected at all the ability of the buyer to in some way obtain that information if there's a problem? Or are they now just without the ability to try to find a remedy to a defective item, or maybe somebody didn't send what the buyer thought they were purchasing, but now if they don't have the ability to contact that person, let alone process of service, service of process, how do we get that information to the buyer?
So there's a couple of things in that one. The way that the bill is written, there will be seller information that is given upon request, but the confidentiality piece that I put in there was so that it's not made public, because the argument that was being made was, okay, we have a sole proprietor who is selling from their home, and that there was an invasion of privacy, and that a buyer, if they lived in the same city, this was the red herring argument that they made, that a person could come to their house and then try to deal with them. And so I was sympathetic to that. And I understood that as a person who lives in a house and you may be making pillows, you don't want to have a confrontation or someone coming to your house to deal with what they felt was a defective issue. So I put the confidentiality provision in there to have the marketplace give that information upon receiving that complaint, but it wouldn't just be outwardly public, because that was what they were debating, was that this information was so public that a person could find themselves in a risk situation. And so that is how I tried to deal with that, which is it's confidential until you have a complaint from a person, and then you should disclose to that buyer, but it's not just an open, here's my address, it's all out here on the internet. That's how I was trying to deal with it. So.
All right, no, I appreciate it. I just, and you've answered the question, they still can get it if they need to resolve a dispute. So I'm satisfied. Thank you.
Thank you.
Additional questions? Seeing none, I'll entertain a motion for amend, do pass.
I'll move, amend, do pass.
Have a motion from Senator Pickard. Do I have a second?
Second, Senator Lang.
Have a second from Senator Lang. Further discussion? Madam Secretary, please do a roll call vote.
Senator Hardy,
Yes.
Senator Lang,
Yes.
Senator Neal,
Yes.
Senator Pickard,
Yes.
Senator Scheibel,
Yes.
Senator Settlemyre,
Yes.
Chair Spearman.
Yes. Okay, let the record show that the motion does carry. Senator Neal, would you take the floor statement on this?
Surely, Madam Chair.
Thank you. You sound so enthusiastic.
I'm sorry.
down to Senate Bill 320.
Thank you, Madam Chair. For the record, Cesar Magrejo, Committee Policy Analyst. Our next bill is Senate Bill 320, which enacts various provisions relating to food delivery service platforms and sponsored by Senator Neal and heard on March 30th, 2021. There is also an updated proposed amendment on Nellis. I will make note of what are the differences between the language included in this work session document and what's included on Nellis. However, the most updated language is included on Nellis. The First Amendment is to amend Section 12 to clarify that a food delivery service platform must enter into a written agreement with a food dispensing establishment. Second Amendment is to amend subsection 2 of Section 13 to delete immediately and provide that the food delivery service platform is required to remove the food dispensing establishment within 48 hours after receipt of a request of the removal. And the amendment number 3 is what I've identified as the difference between the two submitted amendments. So it's the new proposed amendment would amend subsection 1 of Section 16 to delete that before an online food order is consummated with a user, a food delivery service platform must disclose any commission associated with the online food order. In addition, include in subsection 1D that the platform must disclose in a statement the average commission expressed as the highest possible percentage paid of the aggregate food purchase price by the provider for a food dispensing establishment in Nevada. Next amendment is to amend subsection 4 of Section 16 to provide that if, after consummation, the user is provided a receipt of the online food order, the receipt must disclose in plain language and in a conspicuous manner the total online food order price and the price attributable to the food purchase price, any tax and any delivery fee for service fee, and any gratuity to be paid to the delivery person. The Fifth Amendment is to delete subsections 1, 2, and 3 of Section 17, which sets forth the manner in which the commissions are required to be disclosed. And amendment number 6 to amend subsection 4 of Section 17 to delete the term commissions and replace with information. Amendment number 7 is to amend subsection 1 of Section 19 to prohibit a food delivery service platform from charging a food dispensing establishment a commission for an online food order that exceeds 20% of the food purchase price of the online food order, plus a credit card processing fee. In addition, allow a food dispensing establishment to agree in writing to pay food delivery service platform provider a commission that exceeds 20% of the food purchase price to obtain certain optional products or services. The last amendment is to amend subsection 4D of Section 19 to provide that for the purposes of Section 19, the meaning of food dispensing establishment does not include a grocery or convenience store. And Madam Chair, I believe that's all the amendments.
Thank you. Committee members, questions? Senator Pickard? Oh, I just do that automatically.
Well, thank you, Madam Chair. I was just contemplating whether or not I wanted to commend the Restaurant Association for their hard work. I got a call late last night because they were still working on the amendment, and I certainly appreciate their willingness to make adjustments based on what the committee had to say. So kudos to them, and I'll make a motion to amend and do pass.
Second.
A motion from Senator Pickard. Who's second?
Settlemyer.
Senator Settlemyer, second from Senator Settlemyer. Further discussion?
Yes, Madam Chair. I just want to ditto Senator Pickard and thank Alexandria. She's on because when I say that this was a challenge, it was, and she took it on because I was just like, I don't want any more gray hair, but I will pass all that on to you. So thank you, Alexandria.
Thank you. They say gray hair is a sign of wisdom, so in a couple more years, I may be deemed very smart. Madam Secretary, please do a roll call vote.
Senator Hardy,
Yes.
Senator Lang,
Yes.
Senator Neal,
Yes.
Senator Pickard,
Yes.
Senator Scheibel,
Yes.
Senator Settlemyre,
Yes.
Chair Spearman.
Yes. And let the record show that the motion does pass. Again, Senator Neal, would you take the floor statement?
Yes, ma'am.
Thank you. And so I think that's all of the work session documents that we have. So now, broadcast, we will go to public comment.
Thank you, Chair. To speak in public comment, please press star 9 now to take your place in the queue. Chair, your public line is open and working and you have no callers at this time.
I'll wait just a little while longer in case someone is having some technical difficulty.
Thank you, Chair.
Still no one on?
Correct, Chair. You currently have no callers at this time.
Alrighty, so we'll close public comment, and we will bring this marathon meeting to a close. We shall meet again tomorrow morning at 8 o'clock, and we have some more bills to discuss. I want to make sure that we get, to the extent possible, bills out in work session that we've already heard. If anyone has a bill, you're waiting for an amendment, please ask for conceptual. I don't think they're doing mock-ups right now. Ask for conceptual so that we can get it out of committee after the 9th. It'll be too late. Okay. And so with that, we are in adjournment.